got one just like yours over here. I'd like to call this regularly scheduled Real Estate Commission meeting into session. I'd like to welcome all of those that's in our audience. For whatever reason you're here, we hope you find that this day is going to be productive and you're going to learn something that will be beneficial to you in your continuing journey in the profession of real estate in Tennessee. At this time, I'd like to call on our Executive Director, Ms. Eve Maxwell, to call the roll.
This meeting's date, time, and location have been noticed on the Tennessee Real Estate Commission's website, included as a part of this year's meeting calendar since September 7th, 2012. Additionally, the agenda for this month's meeting has been posted on the Tennessee Real Estate Commission's website since Thursday, January the 2nd, 2014, and this meeting has been noticed on the 10Gov website since Friday, January 3rd, 2014. The roll: Alexander.
Here.
Bloom.
Here.
Collins.
Here.
DeChara.
Here.
Flitcroft. Franks.
Here.
Grease.
Here.
McMullen.
Here.
Stevenson.
Here. As the roll was being called, you heard a name that you have not heard before as the roll has been called, those of us who have been here. And that name happens to be Franks. She has a first name. Her name is Marcia, our new commissioner, and I'd like to welcome you, Marcia, to our commission. And at this time, it's customary, and has been, the number of years that I've been on this commission, that anytime we get a new commissioner, that they introduce themselves to the rest of us and tell anything that you'd like to share with us about yourself that you wouldn't mind having on a record.
Okay.
So the floor is yours.
Thank
Our
you.
newest commissioner, Miss Marcia Franks.
Thank you. First of all, I'm honored to be with all of you guys. I consider all of you giants in the real estate business in Tennessee, and I really appreciate being here. I'm from Franklin, Tennessee. I'm representing the Middle Tennessee on this commission. I have lived in Franklin for 35 years, and before that in Nashville. I've been a realtor for 27 years. I've owned my company, Franklin Realtors, for 18 years. Have enjoyed the real estate profession, and am looking forward to my time on this board to further the real estate commission and the professionalism there. I have two children, both grown daughters, and I have one grandson, 4.5 months. He's my pride and joy at this point. So appreciate you giving me this time.
Thank you, Marcia. Does any of the commissioners have any questions of Marcia?
Oh, no.
That she did? Things that you might be curious about that she didn't share? But if not, you just at lunch and as we're for the next time, because you've got a 5-year appointment.
Okay.
So 5 years, and it will pass very quickly. At this time, I'd like to call on one of our Middle Tennessee commissioners, Mr. Austin McMullen, to lead us in our invocation.
Thank you. Let us pray. Eternal God, we thank you for this day and for this life that you've given us. We pray that we would use them and use all the blessings that you've given us to your glory. We lift up all of those who are in positions of authority and pray that they would serve the people with dedication and energy. And especially, dear God, we lift up this board and pray that in all things your will would be done. In your holy name we pray. Amen.
Amen. Next on our agenda is to adopt the agenda. And there's one thing that I would like to put on our agenda, and I'd like to put it right after we approve our minutes, and that is a part on our agenda for the adoption of the Robert's Rules of Order. We have been reminded that every year we need to go on record as adopting the Roberts Rules of Order as our official guide to the way we conduct these meetings. So I will add that to our agenda right after the approval of the minutes. Does anybody else have anything they'd like to add to our agenda?
Move to adopt the agenda as amended.
Second.
I have a motion by Commissioner McMullen, and a second by Commissioner DeShara to adopt the agenda as amended. All in favor say aye. Aye. Opposed, no. Motion carries. The agenda is adopted as amended. Next, our minutes.
Got November and December.
We've got November and December minutes.
Motion to approve November, December minutes.
I have a motion by Commissioner Collins to approve our November and December minutes as presented. Do I hear a second?
Second.
Second by Commissioner DeShara. Any discussion on the motion?
Mr. Chairman, I think there was just a typo where, isn't that the last month's minutes where Janet was shown as the vice chairman?
Oh, I moved up, did I?
It's just, I move we correct that if I'm right.
Okay,
I'll second that friendly amendment.
we have a friendly amendment that we,
Oh, it's got Michelle as vice chair.
Okay.
okay, we'll correct.
That's in the November
that November?
minutes.
In November, we'll make a correction. Note Ms. Maxwell to correct that. The motion has been amended with a friendly amendment to change Michelle Haynes from vice chair to just a commissioner. Any other,
It's actually, that's in November and December.
both months?
Yeah.
November and December, okay. We'll correct it. Thank you for pointing that out. We'll make that correction. Anything else that you see before we vote on the motion to approve our minutes? Hearing nothing, all in favor say aye.
Aye.
Opposed, no. Motion carries. The minutes are approved for November and December. The thing that was added,
Does Commissioner Franks need to abstain since she wasn't at the meetings?
I did not vote.
Yeah, okay.
yes, very good, Ms. Crop. Let the record show that our new commissioner, Marcia Franks, abstained from the vote on the approval of the minutes for November and December. Does anybody like to make a motion?
I'll make that motion, Mr. Chair, that we adopt Robert's Rules of Order.
Second.
Motion by Commissioner DeShara and second by Commissioner McMullen that we officially adopt Robert's Rules of Order for the ways in which we conduct our meetings. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Robert's Rules of Order is adopted. Next, we have our legal report. And I'd like, before we get into this, I'd like to remind all the attendees that are here, if you have any kind of a cell phone or electronic devices, that you silence them, and we'll have a break. All of us up here have some kind of a business. I know Mr. McMullen down here, he's an attorney. He's got his law practice. He's one of two consumer members that's on the commission, but the rest of us are realtors, and we have our own businesses. We've got business that we're working on currently, and we're at a break. We're going to take a break here about 10 o'clock. So we'll be on the phones returning calls and doing things, and that's what you do. So while you're in this meeting and while it's in session, we want your attendance, we want your attention, and just want to make sure you turn all your cell phones and electronic devices to the silence. And with that thought in mind, our legal report will be conducted by Julie Kropp, who is the attorney for the Real Estate Commission. She is also the legal counsel and the attorney for the Auctioneer Commission. So she's got two commissions, Real Estate and Auctioneers. And I just want you to know that we missed you in December. She was a little under the weather in December.
A lot under the weather, but I'm better now. Thank you.
We missed you, but we're glad you're back with us.
Thank you.
And with that in mind, the floor is yours, Julie.
All right. The first matter that I have to take up is the discussion of the rule drafts that you all looked at last month, and you went over with Miss Ryan. I had prepared those, but since I was here unable to speak, so I was not here, she discussed those with you all, took notes of your recommendations of changes. I have worked those into revised copies for this month. I sent these to you all ahead of time to look at before today because it was told to me that you all plan to hopefully approve these rules for rulemaking and begin with the regulatory flexibility analysis and move forward with the rulemaking process beginning today. So I have a copy of a notice of rulemaking hearing, which I've gone ahead and filled in with the rules, noting the changes that I saw in her notes of the things you all wanted altered. And I guess we can take these one by one, or if I can turn the floor over to you all to address any concerns you have, whichever way you would prefer to do it. But just looking through the substance of the rules at this point and seeing if this is how you all, if this reflects how you all want them to be moving forward.
Chairman, I'd recommend we do these one by one.
Second. Have a motion, I guess you made a suggestion, I think we just put that in form of motion, that we take these one by one, and it was seconded by Commissioner Bloom. Alexander. Commissioner Alexander seconded that motion, that we take them one at a time. Any discussion on the motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. We'll take them one by one.
The first rule would be a proposed new rule 1260-01-.18 called duplicate or confusingly similar firm names. Are there any comments or anything to discuss regarding this proposed new rule?
Mr. Chairman.
Commissioner McMullen.
Julie, on paragraph number 2, the first sentence where it says the commission staff shall review all applications for a firm name to determine whether the name is the same or confusingly similar. I think there needs to be something added to the end of that sentence that says something like confusingly similar to another approved firm name or something like that.
Like to another licensed firm, perhaps?
Name, because you're talking about
To
comparing.
another firm licensed with the commission?
Yeah, the name of another firm licensed with the commission.
Okay. To the name
Because it needs to be same or similar to something.
of another firm
Yeah.
licensed with the commission.
I have a question there.
Yes, sir.
What are you going to do about these people that you already licensed that has the same name?
We cannot go back and withdraw approval for people that are already there, but this would be including the entire firm name. I mean, this would be somebody that comes in. I'll take Janet, for example, since I know you have a name and a DBA name. It would be taking the name in its entirety and considering if it's duplicate or confusingly similar to the entire name there, not just part of it. It would be the entire name, would be my understanding of the intent of this.
Just a comment on that, because recently I know a new firm that was approved that was in the name, it was the same name of another real estate company in our area, but it was all part of a DBA kind of thing. I have a real issue with the names being that similar, even in that format, because with the new rules, they're going to be able to use either or name. So if they choose to use the same name as another company, it's okay according to what we'll be saying. You understand what I'm getting at?
I understand what you're saying. I think that, you know, this is something that I'd taken from a policy, and it's of course up to you all. The way I had read it was that it meant the entire name. Now, I know some people don't have DBAs, and I would assume that the primary concern here for the public would be not even people necessarily involving DBAs, but just taking names that are similar to very recognized firms, perhaps in small communities, and kind of creating the confusion that they are the same. I know that there's some larger companies that have the same DBAs, and they're all technically, I mean, they're all a part of one big group, and I wouldn't think that that would necessarily pose the same threat to the public as somebody coming in and trying to spin off the name of a very recognized local firm and make it look like they're part of the same one. I don't know if, you know, if you all want it to be intended, I mean, that way, then that's something that the staff can look at, because it does say the firm name licensed with the commission. The firm name that's licensed with the commission is the entire name, so.
But the way that's written, if it says as the firm name, not the entire firm name, would the commission not have the right to refuse somebody's license because they were using the same name as another company, whether it's their DBA or not?
Are you talking about a new applicant or somebody that already has?
A new applicant.
A new applicant.
Okay, mine is NYPD LLC, DBA Exit Select Realty. Okay, so why in the world anybody would want to do that again? But if somebody else came in and wanted to be Stevenson Realty and Auction, DBA NYPD LLC, which is just backwards of my name, you know, then why would you allow him to do that?
I mean, what has the practice been when this was a policy, when things like that came up?
When it was a policy, the person could advertise in the whole name, like NYPD DBA, or in their DBA name alone. The policy had a 50-mile limit for the deceptively similar names, so that we only came across it a few times, and it was usually with smaller firms that were, you know, it's firms in a smaller market where they were trying to play off the name of an individual who, I guess, had a business or a well-established reputation in that area. This right now it applies statewide, so it would be a little different consideration, I think, than what we've had before. We have turned down, since I've been here, probably a handful of firms because the names were deceptively similar or exactly the same. And it appeared that it was the same person trying to use it to get around some sort of a rule with MLS, or, you know, it appeared that they had.
Well, I know we did just have it happen in our area, because the board office called me and said, how am I supposed to put this in our system, because they have the same name as another firm.
Exactly the same name?
And, well, they're a franchise, and they just tacked the other company's name onto the end of theirs. So they are franchise name plus another firm name. So that's exactly the same, that firm name is. All they've done is added a franchise to the front of it. So now we've got two firms in our area with the same name.
Exact same name. Yeah, well, as I say, normally those, that wouldn't be approved. I don't know really all the circumstances that surround that, so I don't know, because most of those come to me and I don't remember that, but I can look into that. But that is a problem, and just like what we talked about before, where you have the franchise name and they all DBA in the same name. I mean, like I said, they all DBA in the franchise name, but they have a different first name. And the DBAs are what they're advertising in, and so you don't know which one is which. And I don't know where to draw the line, and it's, as we discussed last month, the question of what if the Secretary of State allows it, because it looks like they allow pretty much anything that is that even has a difference of an LLC or a corporation. So then that puts a burden on our staff to then make a distinction where the firm has already been approved by the secretary, or at least, not approved to get a license for real estate, but they've been approved for that name. And I don't really know where that leaves us. That doesn't answer your question, but it's something that I don't know the answer to myself, and how that would affect this rule.
Commissioner Grease would like to speak to this issue.
I just want to ask a question. So if a company's name is like Marcia Franks, DBA, Volunteer Realty Company, and there's another company that's Gary Bloom, DBA, Volunteer Realty Company, are those two separate? I mean, they're clearly separate names, but they can be awfully confusing to the public if they're doing business as both Volunteer Realty.
They would be, we would approve that full name because the full name would be Marcia
Right.
Franks, DBA, and then Gary Bloom, DBA. So, and if they both advertised as Volunteer Realty and forgot didn't put their first names on there, then you wouldn't know which was which, except by the phone number.
But I think maybe Janet's point is this rule as it's written at the moment might allow that to happen, because you're taking the confusing names, you're taking the corporate name and the DBA name, and if they're totally different with two personal identities, then I think this rule allows it at the moment.
I think you're kind of back to that question of what's the definition of a firm name? Is it the whole name as licensed with us, or is it bits and pieces of the name? Is that something I know that the commission discussed in December, and I don't know that there was a consensus on what really is the firm name.
We define the firm name in the advertising rule, but that is purely for purposes of that rule, and it even says for purposes of this rule. If you all are concerned, and these are, your rules, these are just drafts that I've done based on my understanding of what you wanted, and this one was largely copied over from the way the policy was written beforehand, then we could say something along, if your concern is the Marcia Franks DBA Volunteer Realty and Gary Bloom DBA Volunteer Realty, and you think that's something that should be looked at as duplicate or confusingly similar, we could say refuse a new firm license in a name, any part of which that is the same or confusingly similar to another firm already issued. Say something, any part of something like that.
I think we've got to have that authority in there for the commission to refuse some names based on people coming into the market. And, it wouldn't be uncommon for a new firm to come in and say, okay, well, Marcia's been in this business a long time. She's got a great business built up, so I'm going to call mine Franklin Real Estate instead of Franklin Realty, and play off of Marcia's reputation she's already gained. If I was a new firm starting out and that was allowable, it'd be a smart thing to do.
I wrote in some notes to subsection 1. I'm going to read it to you all and see what you think about this revision to it, to see if it covers your concerns that you're conveying here. In order to protect the public from confusion regarding licensed real estate firms, the Tennessee Real Estate Commission reserves the right to refuse to issue a new firm license in a name if any part of that name is the same or confusingly similar to another firm already issued.
I don't care for the reserve the right to change it. It needs to be either yes you can or no you can't.
Well, below is, I think the reason why it says reserves the right is because there's this review process outlined below, and it's first looked at by staff, then the executive director, and then they can appeal to you all, and it's just saying you all have the right to do it or not to do it. It outlines a process for the review of that.
From my perspective, I only care about the DBA being confusing. I don't care about any other part of the name. If the DBA is similar or confusing to the public, that's where the issue is, I think. And I don't know whether.
Well, the way we've written this new rule, though, they can advertise in either name. So if somebody has the more similar name on the front end, then they could use that name to advertise to confuse the public rather than the DBA name.
And like I said, it would be the way is outlined below, as it was in the policy, is it would be something that would be reviewed on a case-by-case basis.
Read your suggestion again.
In order to protect the public from confusion regarding licensed real estate firms, the Tennessee Real Estate Commission reserves the right to refuse to issue a new firm license in a name if any part of that name is the same or confusingly similar to another firm already issued. And that's just saying it could be reviewed at that point.
What's the implication of that for franchises?
Since it's a rule, it would be applied the same to any type one. And I realize that some franchises do utilize the same DBAs or very, very similar DBAs, and they would have to be treated the same way as everyone else. And I would expect that when this comes down to a rulemaking hearing, those groups are going to be in strong opposition to this.
Well, I would think so. That's the reason that they have that name for.
Exactly. So that's something to consider.
But we ought not to pass something we're going to be aggravating a lot of licensees with.
Well, but it's not going to apply to those that already have a license.
That doesn't matter.
And-
that's the reason that you want to buy a franchise.
Well, but in part, that is why we are discussing this, is because of one particular franchise that all across the state, you can't tell which firm they belong to. And like with our franchise, we each have to have an independent name that's not like anybody else's. So, I mean, we can't all be Exit Mid-South. And most of the franchises are that way. I mean, I know that Crye-Leike each has their own names attached to them.
And I think in the past, my understanding is and that it's been applied to the whole name, not just the DBA. And so then in that case, those franchises would not necessarily fall under that. But I see what you're saying about the opposing concern, and I don't know how to resolve that. I mean, this may be something that we can't resolve at this point, and this may be a rule that should be, passed on for now. I don't know you all's feelings, but it seems like there's two very distinct opinions on this, and all I know is if we pass this as a rule and we're saying that if any part is confusingly similar, such as the Frank's DBA Volunteer Realty, Bloom Volunteer Realty, that should be reviewed the same way as a large franchise where just the DBA is the same. We would have to apply it evenly to everybody, and there will be a lot of pushback to that. And I don't even know. We have to consider here, our main thing is the protection to the public. That's the goal, and the best way to resolve that. I mean, this is a difficult issue, and I've given it a lot of thought. This policy's been around long before I was here, and it looks like it's getting altered a little bit in the rule process. But I don't know a clear fix. I'm just trying to give you all of the possibilities of what could come up down the road.
I thought
Have
the
you-
intent was for, like, if ABC, capital ABC, was selling franchises, and then somebody in another area used little ABC, and they were not part of the franchise, but to kind of cabbage on that name, that we would not permit that. But capital ABC here and capital ABC over there, that's okay.
And that's where I have the problem, is let's use Nashville, for instance. Exit, and I'll use my franchise because I don't mind talking about it. There's a lot of Exit offices in the Nashville area. There is Exit on all the yard signs, but it also has their individual company name under that logo. That is not confusing to the public because they know I'm with Exit Select Realty and John's with Exit Preferred Realty. They know it's two separate firms. If we go out here and we just put exit on every sign all across this state and somebody's got a complaint, they don't know who to call. Especially in these areas where you may have 10 offices that are that same franchise.
Julie, did you, or have you had a chance to look and see whether any other states have any sort of rule or policy that's like this and how they might have addressed this particular issue?
No, I didn't have the opportunity to do
Okay.
that throughout this past month. Eve, are you aware, have you come across any of that in some of your looking at this? Do you know of any off the top of your head?
There are other states that have addressed names that are similar, and by and large, they do not allow, their blanket policy is they don't allow names that are similar. Now, there are caveats to some of those, and that would be, say, if you have permission from a franchisor and the franchisee, so you have permission to use it. So there's some caveats under those that would carve out the exceptions to that situation. And so, it's kind of, I think, it's how you define the firm name. But by and large, most of the states do look at the firm name as a total is licensed with that, and that's what you have to advertise in as well. So it's a little different from that standpoint, too.
Julie, you think a statement at the beginning of all this said that each firm should research the firm names with the Secretary of State prior to naming themselves? Would that help?
Well, it might in some cases, but then there are some firms that aren't registered with the Secretary of State. And so, and that would be a major concern there, is if somebody's been operating for years and years and it's a sole proprietorship or it's something that's not registered with the Secretary of State and somebody comes in and snaps that up with the Secretary of State, researching there wouldn't be beneficial. And I think that would be kind of akin to what Commissioner Bloom was saying. That's almost the biggest threat of all, is somebody taking a well-established name and spinning it off as their own, and not everybody registers with the Secretary of State. So,
Eve, do we ever, or have you ever, the staff ever gotten a call or any sort of inquiry from somebody in which they say, and I'll just use the name Janet's been using just because that's out there, I want to file a complaint against Exit Realty, and you're not able to figure out which particular either firm or licensee the person is contacting you about?
At least since I've been here, we've been able to, usually we can figure it out just because they know the name of a person, and so that you can track that person back. They may not know the principal broker because they only know the team, but they have a person's name, a licensee's name, and we can usually track it back that way. So that as far as when someone tries to file a complaint with us, we usually have success. They probably don't always have success reaching a principal broker, because frequently that's left off a complaint. They just have Exit Realty and then put whoever they dealt with on it.
From that, you can figure out in the system that John Doe is with this particular firm and this certain person is the principal broker, and get to where you need to go in order to
We
investigate.
can. From the internet right now, one can't get that much information from the internet right now, but we can find that internally as long as they have a name and, that's spelled sort of close to the way it's spelled in our system, we can find it.
Mr. Chairman, I'd like to make a recommendation that we approve 1260-0118 as written.
do you want that to include the two small revisions that Commissioner McMullen recommended, and then the one about the if any part, or just as written on this page?
Of Commissioner McMullen's amendments.
Commissioner McMullen had noted in paragraph 2 that the first sentence should end with same or confusingly similar to the name of another firm licensed
I
with the
remember that.
commission.
That's fine. I accept that.
And then the other one was if any part of that name, and I'm assuming you're not wanting to include that part.
That's correct.
Okay. So with the one revision.
That's correct.
Okay. I just wanted to be clear on your motion.
Yes,
so-
thank you.
Okay, Commissioner Bloom has made a motion that we adopt 1260-01 2022-0-.18, duplicate or confusingly similar firm names as it is presented with these two minor revisions.
No, sir, with just one revision.
But the end of that first sentence in paragraph 2,
Yes, sir.
with that, I thought that somebody had, that
Not-
Julie. that
And you don't
Julie-
have to adopt it right now. You can just
Accept the
accept it for purposes of moving forward.
Okay. So with this, the end of the first sentence in paragraph 2.
Got
that-
it.
And it's been seconded by Commissioner Collins. Any other discussion or comments? Commissioner Grease?
Before I vote, Julie, the difference between this rule as it's being proposed and our policy currently is it the 50-mile issue?
That's all that was noted to be removed from last
Okay.
month on
So
the
this is our
notes.
current policy, moving forward to take rule status, we hope.
I don't think I don't think anything was changed, and nothing substantive anyway. I might have cleaned up the language here or there, but it wouldn't have been anything different. Got it right here, I can
That's
double
good,
check.
that's good.
but-
Thanks.
Any other discussion or comments? Hearing none, all in favor say aye on the motion.
Aye.
All opposed, no.
No,
Let the record show the vote was 7 yes, 1 no. And continuing on, Ms. Crop.
Commissioner Frank's vote, that's only 8 people.
Yeah, she
So-
voted.
So then, there's only 8.
Flitcroft's not here.
I know
We only,
Commissioner Flitcroft's not here.
yeah, there's only 8 of us
Just can't
this
count.
month.
Thank you. All right, the second one,
Julie?
I'm sorry.
I'm sorry to interrupt you, but do we do this Regulatory Flexibility Act after each proposed rule, or can we do it collectively for?
we can do it at the end.
Okay,
I
good.
just want to make sure that we've got them in the correct format, where when we do that analysis, we're analyzing the rules as they will be moving forward.
Thank you.
This is just a final go-through to make sure we have them the way you want them for the hearing. The second proposed new rule is 1260-01-.19, informal appearances before the commission. This was also a policy, but I had changed it because I'd gotten to, before it said any person appearing before the commission for an informal appearance, but I discussed with Ms. Maxwell, the only people that come before the commission for informal appearances and need their principal brokers with them are the applicants that we sometimes have. And so I changed it to reflect that because it appeared that's the only time where it arises within our meetings. So, I mean, when somebody comes to, asked to be put on the agenda just to speak, that's not an informal appearance. The times when we have informal appearances are when we have applicants that have criminal convictions or things of that nature in the past, and they appear and they sit up there. And so that's why I had just kind of narrowed it to more reflect what we've been doing. So
Julie, at one point, we discussed that Ms. Maxwell could have the authority to approve somebody's license if the crime was like 20 years old and something that they did, like smoking pot when they were 18, without having to come before us. Did we move forward with anything on that?
the ultimate resolution with that was it was too much push-pull of how many there were, how long ago there were, and there was no way to just clearly specify it out where Ms. Maxwell and I would have clear in there was always going to be questions. And so the ultimate decision, and I can't remember what month it was just to keep it as is with you all reviewing it.
Mr. Chairman, I'd move that 1260-01-19 as written move forward in the rulemaking process.
I'll second.
Have a motion that we approve 1260-01-19 is presented, and second by Commissioner Grease made the motion. Commissioner Tashara seconded that motion. Any discussion on this motion? All in favor say aye.
Aye.
Opposed, no. Next.
The next one is a proposed new rule 1260-01-.20 military applicants. This is a rule that was drafted as a result of a piece of legislation which was signed into law last session, and it basically follows the format of that that bill, and it said that each commission shall adopt a rule. So this is something that we're going through with all of our commissions, and it's just a process for dealing with military applicants. And I don't believe there were any notes with concerns from last month on this one, but
Mr. Chair, I make a motion that we adopt 1260-01-.20.
I
Motion
said y'all
by,
don't have to adopt it. You can just say except for moving forward.
Okay,
Just
except for moving forward.
have a motion by Commissioner DeShara to move forward on this particular 1260-01-.120. Do I hear a second?
Second.
Second by Commissioner McMullen. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. We're moving forward.
Okay. The fourth proposed new rule is 1260-01-.21, which is entitled Reinstatement of an Expired License of a Broker, Affiliate Broker, Timeshare Salesperson, or Acquisition Agent. This is largely duplicative of an existing policy that was in place before the commission, and it has had some changes. I've spoken with Ms. Waxwell, just making sure that this works functionally through the process, but it's very similar, wouldn't you say, in intent and substance to what was there before. If anybody has any questions, you can let me know, or concerns, but this is just the next one for discussion.
Ms. Maxwell, does this give you what you need to move forward on some of these applicants that have had to come before us because they've had a terminal illness or whatever?
Yes, I believe that it does. Once it's a rule, I think it'll clarify any questions that might have existed previously.
Anybody have any questions of Ms. Crop on 1260-01-.21 about reinstatement of expired license of a broker, affiliate broker?
I make a motion that we move forward on 1260-01-.21.
Second.
Motion by Commissioner DeShara that we move forward on this particular rule, and Commissioner Franks has seconded that motion. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Moving forward on this particular rule.
The next drafted rule is an amendment to an existing rule. It's Rule 1260-02-.02, which is currently titled Termination of Affiliation. And you will see on page 5 of the materials, the underlined portion is the amendment to it. That's the added language. And that is taken from a policy that we had that the commission had adopted several months ago that, would be better included in a rule, and therefore it was placed into this rule because it seemed to be where it fit best. I did not have any notes regarding this one from last meeting, but if anybody has any comments, that is the amendment, the underlined language.
I just have a question. If on item 3, and A says that you accept, or we accept here at the office, a transfer to a new broker when it's received, provided that you receive everything in 5 days.
5 business days,
Right,
yes, sir.
okay. So what happens if I sign for that affiliate and they do some business, and then I don't get that paperwork in 5 days?
Well, the way this is written is that the commission didn't consider that to be effective, that all of those things had to take place for that to be considered an effective transfer.
I understand. So who's responsible for the actions of that affiliate during that 5-day period?
I would assume that there would be no principal broker at that point, right?
Right. I mean, I guess when the principal broker fills out the online transfer, they sign an affidavit that says they're accepting this person, they're responsible for the actions of the person. And so, I really don't know. I mean, legally speaking, I'm not really sure what would happen in that kind of a situation, whether their E&O would be effective or not effective. I think that would be, I'm not really sure. We haven't had that come up. We've had people get the information into us, and so we haven't had that kind of a situation arise.
Last month, we almost had that come up. There was somebody who claimed that they met with their broker and he never performed those actions.
That's right.
But he was, right, that person was also going back and forth about his being released from the other person as well. But that wasn't done online. This only applies to actions that are taken online, so that if you try to transfer online. And so that would be, in the online situation, the principal broker is making the representation, as I say, through an affidavit, that the person's been properly broker released and that he's accepting responsibility for him, that he has E&O and properly
So it'd be the
licensed.
new broker?
So I mean, I really don't know the answer to that question. We just said it would be void from the very beginning. That's a good question, and I don't really know.
And it might depend on the facts of a particular
Right.
circumstance. I mean,
Right.
because I'm sure that there would be two sides there, but it's the principal broker that completes the online transfer
Correct.
and basically certifies all of those things. So absent some strange condition, I would assume the responsibility would be to them to be sure that it got in.
To the new broker?
To the new broker,
To the new
right.
broker.
It's the responsibility of the broker to get the information in. Most of them are sending it in as soon as they do it online. They're faxing it in to us as soon as they complete it online. But that, I mean, we certainly need to think about that, and because, as I say, we do deem it void ab initio if that were to occur, but we haven't had.
What does that mean, void ab initio?
It'd be void from the very beginning, as if it never happened.
So the releasing principal broker still has the responsibility?
Well, but see, you can release you can release someone without any payment of a fee, or, really all you have to do is send in the form. Most of the brokers that are the releasing brokers in these situations are actually faxing the form to us anyway, so we're getting the release form from most of those brokers. Most brokers send those in anyway.
Okay, but I have a real issue with that. If I release Marcia to go to work for Gary,
Right.
as far as I'm concerned, she doesn't work for my firm anymore. I have signed the release, and she's gone to Gary's firm. Gary goes online, puts it in the system, lays it on his desk for his secretary to mail. She gets sick and goes home, don't come back for 3 days. It's still laying on Gary's desk. In the meantime, Marcia goes out and does something she wasn't supposed to, gets a lawsuit filed against her, and you're going to go back and hold me responsible for it?
Well, as I say, most of the releasing principal brokers now fortunately know they need to fax that Truck One in, releasing the person regardless. It doesn't matter what the person tells you. You need to go ahead and send in that one part of it, because we can go ahead and do that. And as soon as we receive a broker release, we release the person from the firm, so that if we received a broker release from you of Marcia, we would have already released her. And then we would have the transaction where then she joined Gary's firm, and that would really be the question of where she was. Like, was she in broker release? She was in broker release, really, and then she went to Gary's firm. So I'm not, I'm not really sure. And maybe we don't make it void from the beginning. Maybe we should hold the person responsible for those few days. I mean, I don't know. That would be the commission's decision.
Who you holding responsible for 2 days? The old
Well,
broker
no, I
or the
just
new
said,
broker?
no, because once they're broker released, they're broker released, and we're not
That's
going
right.
back against the old person, because you can broker release someone without their doing any other action. So, and that's what we encourage everyone to do. If, in fact, what I'm saying is, I don't know whether we would hold Gary, and I don't know whether we
Why would you
should
not
just-
hold Gary?
Well, that's what I'm saying. So if you don't send it in those 5 days,
If he doesn't send
then,
Well, it's his obligation to get it in as the broker.
right, so then if he doesn't get it in, maybe we don't hold it void from the very beginning. Maybe we just say it's void at that point. I mean, I don't
Your E&O
know.
follows you wherever you go. So you're not gonna have a lapse there.
Well, I don't know whether if you're broker release and you were doing, and you were engaging in activities, if you would then be covered by the E&O. I mean, I don't know the answer to that question.
Well, I think I'm not sure that broker needs to be just let off the hook and it be voided for sure. maybe a civil penalty for him not sending it in or something is better. I mean, because if Marcia's out here practicing real estate thinking she's got a new broker,
Right.
and then he doesn't do the paperwork and she gets into trouble, then we're going to go after her for practicing unlicensed activity.
Right, while she thought she was
Because she didn't
licensed.
have a broker when all the time she thought she had one.
Right. I mean, and the whole idea was to encourage the brokers, obviously, to send in the paperwork so that we had an affirmation of that. Because right now, when you pay the way the transfer online is set up, when you pay the $25 and send in the information, unlike the renewal, that $25 does not go directly into your file, and show up as money on your file. It actually just, we get an email that says it's been done, and the money goes into just the cashier's office on a normal basis, and then must be put into the file. And so, in order to encourage the people to get the paperwork in, and since it wasn't automatic, that's why we put that 5 days in there.
And I'm not sure that's long enough.
And maybe that's not, and we talked about 10 days, but the whole thing was if we were going to make it void from the beginning, we said, well, we don't want them to have 2 or 3 weekends, because we sort of thought a lot of times it would happen on a Friday. And that might have been a misconception on our part when we were trying to structure the online transfer system. And so, as I say, it's the commission's decision whether or not, you would like that structure changed, and either hold the principal broker who didn't send the information in responsible for that person.
And I
for-
think it would be a case-by-case
Yeah, I think
basis
it probably would,
determination.
too. And, it may be that if your secretary was sick for, 3 days and and you call and say, gosh, she was sick or in the hospital or whatever, and I thought she had sent it in, then, we would work with you on that. But, I mean, if the commission thinks that there should be a different way to handle that or to look at that, then certainly that's the commission's decision, and we're,
The chair would like to recognize Commissioner Grease.
Real life principal brokers love this option of transferring agents immediately online. They love it because otherwise an agent and the listings that may or may not transfer with that agent are in limbo for sometimes 2 or 3 weeks. I'll bet you, and I could be wrong on this, that this has probably never been abused since this policy was in place. The transferring agent has got every reason to make sure it gets done quickly. The new principal broker's got every reason to make sure it's done quickly. And frankly, in my mind, if it's not done quickly, then my own sense is that's a failure of the new principal broker to supervise, and we might have some sort of disciplinary action at that point. But my sense is that this reflects, and I know we're not out advocating the position of principal brokers or licensees, but this has been a well-received and accepted policy that people are very comfortable with. And I would say let's move it on as it's written. And
Would you
if there's
like-
some input? Yeah, I'm about to, if you just give me a dang. No, Paul.
We'll move forward.
I formulated this entire presentation. Now you've interrupted.
Your policy that you wanted.
Would you like to make that a motion?
I'd move that this move down the rulemaking process as written.
Commissioner Grace makes a motion. We move forward as this is written with this particular 1260-01-21. Do I hear a second?
Second.
Commissioner Collins, second motion. Any other discussion or comments? Hearing none, all in favor say aye.
Aye.
Opposed, no. We're moving forward. Now,
Chairman, you told this audience you was gonna take a break at 10 o'clock, and it's 10 o'clock. I'm taking one.
we are recessed for 10 minutes for a short break.
I'm kind of like Gary, I'm that's the right thing to do.
Well, you can broker, I got thinking, you can broker release anytime and you're through, period.
As long as you back.
The action is the receiving broker. There's an issue there, which might even be.
Responsible person.
Yeah, might even have to be resolved legally.
I don't
We
think
should, probably
voiding
shouldn't get
that,
involved.
no, transfer is the
I
right thing
thought
to
that
do.
through while you're talking.
I don't think, because
what
the
we talk
agent
about.
thinks everything's been done right.
Yeah.
I'm not
Good
sure
job.
all daisies enough the way it piddles around.
I'm in
people.
Nashville. I'll be
Where's
back.
the restroom?
I'll be back tomorrow
Thank you.
night.
There-
Let's let it
right
warm
there.
up and we'll do some work
'Cause
next week.
When
Okay,
they
Billy Joe.
get
Appreciate
an
you.
application here,
Okay, bye.
it doesn't come directly to the office. Does it go? It goes to the accounting department first. And then once the money is processed, then they have to have.
Ho, 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 ho.
I'm ready for a drink.
That's rough.
You need to get on commission.
I'm on the hot seat down there, and I've got a ways to go.
We're getting the easy ones done first.
Thank you guys so much. I couldn't tell you before, but thank you. I enjoyed the
Here. I think it was the flu or something. I can't tell. I had a coffee. It was over a hundred.
She did.
Voice was about
Mine
like this.
was that way for
So it was. It took me about a week to get over it, and longer than that to get my.
Or what's your brother's name?
Yeah, you get off. You say
Well, we got the tree up and we just didn't decorate it till a little bit later. I felt so bad for calling in and this and putting that on Robin and cleaning and all, but I didn't want to get somebody sick right before the holidays, and I couldn't talk. I couldn't. Would have been
like
one
that, didn't he?
Probably did.
Oh, we missed you.
He knew better than to say it, but he probably did. He did send me to the other bedroom to sleep because it was
Did you?
cold. I did her commissioner
I
orientation.
mean, did you know him before that?
No, I didn't. It was a going to be an ALJ only one, and then it got a continuance. The judge,
We won't even be here tomorrow.
there will be nothing tomorrow now. So, and I think I don't see any reason why we won't finish today. So, I like your sweater, by the way. That's
Hey, Peter, John Grease, returning your phone call, 865-604.
Ooh, thank you.
no, it really is. I like that color though.
I think they sent a work order and they fixed it somewhat.
I guess that's for that day.
But we don't even ask people that. We do ask them. But you know it. You know it.
I just went there. I didn't graduate from high school.
So they get you in free? Yeah, that would be great, wouldn't it?
Coffee and water back here.
Yes, I got me a water. I'm not a coffee drinker, but I do drink water all day long.
I do.
Yes, sir. Always thirsty.
Please put on your calendar. Be sure to be there, yes, please.
Put Robin on there.
Yeah.
Robin,
That would be very good.
slit my throat.
She will find me.
Well, I know, I'll come up here. Like a mad dog. Come to your city hall and find you, what I'll do.
It's on her way.
Everybody already knows that
I
I'm
know,
there.
you've been in the paper a lot.
I know. Are we going to have a hearing tomorrow? You know?
No. the reason I'm frustrated. There are other issues too, but in discussing.
Oh, that's what he said.
They're kind of, this is the way it is.
Yeah, that's what he said.
I call this commission meeting back into session. Ms. Crop, I'm going to just turn it back over to you and let you continue on.
Okay, the next new rule is an amendment to an existing rule. It's 1260-02-.09. It was previously titled Deposits and Earnest Money, but the revision to the title is Managing Escrow or Trustee Accounts. And it just is basically, I'd worked with Ms. Maxwell to address some of the concerns that we talked about in here and just some of the things that she saw, you know, some ways to kind of specify this rule and make it a little more clear to licensees. So in the management of the money in their firm, just give them a little more guidance, because I think it's an area where questions come up quite often, and the rule as written before didn't quite address those. So I don't think I had a lot of notes on this one last month, but I did make I think I made any changes that were noted on there. So if anybody has any comments, or this is the time to discuss this one.
Chairman.
Mr. McMullen.
Julie, I had a couple of questions about this one. Mostly kind of, I guess, more form questions, but it could get into some substance. Like, for example, using your defined terms, you define trust money. And so I'm looking at the new paragraph number 2 that starts off, each principal broker shall maintain a separate escrow account for the purpose of holding. And then you use any funds which may be received in his fiduciary capacity as deposits, earnest money, or the like. Could you replace any funds which may be received in his fiduciary capacity as deposits, earnest money, or the like with your defined term trust money?
I don't see a problem with that off the top.
Or was that intended to be something different?
No,
and maybe you could take that, you know, the any funds which may be received in his fiduciary capacity as deposits, earnest money, or the like, and incorporate that into your trust money definition.
Mm-hmm. I think either one of those would be possible. I mean, I don't really see any difference. Trust money, I'd put that term in there because of some additions that we'd done later on down in the rule, and this was the existing language, so I overlooked that, and I don't see any reason in looking at that why it couldn't be replaced in Part 2. Trust money would cover anything. It doesn't even, limit it to deposits, earnest money, and then it says or the like. I mean, we could just say for the purpose, each principal broker shall maintain a separate escrow account for the purpose of holding trust money received by the principal broker in his fiduciary capacity. I don't know how you feel about that.
Yeah, that would be. I just like using the defined term. You defined it for a reason, so if you can use it. Are the deposits not trust money?
Deposits, I just want to make sure that the
Okay.
rental deposits are,
And it might be that wasn't the intent of the term, so I don't want to mess up what you're trying to do, but maybe
11, all trust money received,
or maybe
which relates to
maybe
the property.
deposits are not supposed to be trust money, but when you use the word earnest money, I mean, maybe that is supposed to be trust money. you do use that term a lot in the old rule used that term deposits and earnest money in a lot of places.
So, like 11 talks about security deposits. So if that was defined trust money, would think that would still work with 11?
I think so,
mean,
and that's the reason why
I think that's
we
why,
created
yeah.
the definition with respect to 11.
Okay.
And that's addressing money relating to the lease of the property, such as security deposits
Right.
and things of
So
that
then you could
nature.
use the defined term in
In two.
and it would be okay.
But
Because
if
it
that's-
actually
Right.
references two in subparagraph
Yeah.
11.
If
so-
that's the only, I mean, if you were really only intending to use trust money in 11, that's fine. I just was trying to make sure if it was the same concept that we use it elsewhere, but if it's a different concept, I'm okay with that.
I don't think it's necessary. It wasn't necessarily a different concept. We were more focused on trying to specify the new part. I think
Yeah.
it's just something that, I mean, we could do that to make it cleaner, and I don't think it would hurt the meaning behind it, so.
The other question I had is that, and I know we had some discussion about this before, I think, what the difference is between an escrow account and a trustee account. I think this was last month, so Julie, you may not have had the benefit
I
of that.
did. Somebody asked me about it, and the reason for keeping that term was because I believe that's how it's referred to in the statute, and it was for consistency's sake between the statute and the rule.
I think that's a good reason to keep it. In this rule, there are places in which escrow account is used by itself, and then other places in which it says escrow or trustee account. Let's see. I know in paragraph 2, it just talks about escrow account.
Old paragraph 4, new paragraph 5.
And we can change that to put separate escrow
Yeah.
or trustee account. That's an easy
Right,
fix.
yeah, the like Gary was saying.
I'm
the new-
sorry. Sometimes when you're rewriting these, I didn't catch some of this stuff, so.
So just for consistency, I would suggest using escrow or trustee account throughout.
Okay. And escrow and just do that. I'll double check through that because that was certainly an oversight in drafting it. I got caught up in the substance of what I was adding and might have
you're-
missed that in some of the old parts.
You're doing fine, thank you. Those were just my only comments about
With
that rule.
regard to the new paragraph 2, what is the commission? I mean, if somebody would, I know would you like to change it to use the term trust money or leave it as is? What is the feeling of the commission on that? Just so I have some direction when I'm changing this for.
But back to Austin's point, if we've defined what it is, and let's use the
Okay.
term, that's my sense.
Each principal broker shall maintain a separate escrow or trustee account for the purpose of holding trust money which may be received in his fiduciary capacity. Would that work? I'll read it out. Each principal broker shall maintain a separate escrow or trustee account for the purpose of holding any trust money which may be received in his fiduciary capacity. Austin, does that?
I think so.
Sounds good to me.
And you just might want to look at the whole thing kind of for that same concept where it's talking about earnest money in some of the other paragraphs too. Just check that to see if you ought to use that defined term trust money in those
Okay.
situations maybe. Motion to approve the rule or to move forward with the rule as amended.
Are you making reference to 1260-02-.09
Yes, sir.
in its entirety with the minor changes that we have discussed? And
Absolutely.
We have a motion by Commissioner McMullen. Do I hear a second?
Collins.
Commissioner Collins seconds that motion. Any discussion on this motion?
Yes, Mr. Chairman. Old paragraph 6, new paragraph 7, item A, upon a reasonable interpretation of the contract which authorizes him to hold such funds, is subject to very subjective decisions by people Okay, right now we have a lot of sales where one broker represents the buyer, another broker represents the seller, and there can be validity on both people's sides as to who gets the earnest money. And what we've said here is that if I'm holding the earnest money and one of the other individuals on this board is representing the other side, I can declare it's my reasonable interpretation of the contract to give it to my client. And they can argue all they want to, but I can give them the earnest money according to this rule.
That's how it is now, I think.
That's how it is currently.
That's exactly how it is now. But when we go through the next exercise, which says that all these rules have to have clarity and not open to different interpretations, I don't believe that matches.
You know, along that line, Gary, what you're talking about, I have never, when there's been a disagreement with the disposition of earnest deposit, when a deal falls apart and goes south, I have never felt comfortable personally making that determination because I'm not a judge. I've just always interpolated it.
Yeah.
Yes, sir, and I think that's what we ought to do. But recently, there have been some things that have happened in my market where individuals took it upon themselves to distribute, in one case, $10,000. And so what we had to do to resolve that was go to a trial, which, in my opinion, we created by 7-A. We allowed that to happen.
Well, don't you think the contract was more important than this rule, proposed rule? He released that money based on a term in the contract, not anything that the Tennessee Real Estate Commission has done. Somewhere in that contract, it said he had the right to do that.
Right, but the other side said, "Oh no, you misinterpreted that."
No, but then if he wants to do it, I think that's his right as a principal broker. But I don't think it's based on our action. I think it's based on inside the body of that contract what he was authorized to do. I don't want to get mixed up with our rules and contract. I mean, they're different. I mean, a contract might say if he can blow 10 bubbles, he can release it,
Gary,
which is not even an option in ours.
we get both parties to sign the release form that TAR has, and if they won't sign it, then we immediately take it to Interplete and tell them that's what we're going to do.
I think that's
my
what you
counsel.
should do, but we have an option in A to do something different.
Well, they always take the risk, though, that
Yes,
somebody
sir.
comes back later and says that wasn't reasonable, and a judge decides that it wasn't.
Right, and I
done
think
pursuant
for
to the
years, we've
contract.
all assumed that, oh, I don't want to be sued, so let's interplead these. But there are individuals who look at A differently.
But if they make the wrong interpretation and a court rules differently, then even though they do have the authority to do it,
I'm just
That-
asking, why would you give a broker that authority?
That's pursuant to the contract that has been signed, that's what he's supposed to do. And so I don't think we want to say you have to interplead it every time if there's a contract that says he can do a certain thing with it and he's determined that those things have been done. He takes the risk, though, that somebody else, a judge, looking at it later, says that those things hadn't been done.
And the contract's what's enforceable.
what's your pleasure?
Call for the question.
We have a motion on the floor by Commissioner McMullen, second by Commissioner Collins, that we move forward in its entirety as presented with amendments that we've discussed. Any other discussion or comments? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries unanimously.
The next proposed amendment is an amendment to an existing rule, Rule 1260-02-.12, titled Advertising. I know there were some comments last month. I attempted to clarify those, and we can discuss any further comments based on the changes that were made at this point.
I want to talk about C and B again.
About which ones, I'm sorry?
C and B,
Is that two?
2C and B.
Okay. See, and
2, C, and D. Gotcha.
Where you say you can use it interchangeably as long as it's registered with the Secretary of State. Well, you told me a while ago that you didn't have to register those names with the Secretary of State. Those firms that are licensed outside of the state of Tennessee does not have to register with the Secretary of State. So why, we have no authority over the Secretary of State and what they do.
I agree with you.
And this is the regulatory board for the Tennessee Real Estate Commission and the licensees of this state.
I agree with you.
And I would move that C and B be removed from this.
And I included this because it was reflected in my notes that it was the motion of the commission last month. I agree with your comments.
you're wanting to delete 2 and C and D, as in
C.
dummy.
C and D,
The Secretary of State part.
the
I think
Secretary of State part.
What he's saying is it gives 4 possibilities, and some of these could be out-of-state firms that that are registered in places other than here, and it's a lot of avenues to explore. And really, we license them in a full name, and some people have DBAs in their license name here, and that's covered by A and B. And I think just what you're saying is not everybody even has it. There's a lot of places to look, and I agree with what you're saying.
Are you making that in the form of motion, Commissioner
I am.
Alexander?
Yes, I am.
I'll second that.
We have a motion by Commissioner Alexander and seconded by Commissioner DeShar that under Rule 1260-02-.12, Paragraph 2, subsection C and D be removed in its entirety. Any discussion on this motion?
Now, we're just talking about this issue, right?
This one is C and D, that's it. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. C and D under paragraph 2 has been deleted in its entirety.
Mr. Chairman,
Mr. Grease.
so since I've been on this commission and since I've been in real estate a long time, I've been confused about this notion of whether a licensee has to advertise as owner or agent. And I've been assured by members of this commission that if it was true at one point, is no longer true today. True. This is my main source for that. Okay. I cannot see where it would hurt at all if, and by the way, Julie, I think you did a great job of summarizing our discussion on advertising not being here.
I had a lot of help with, Robin gets the credit for that.
And we didn't even.
And Steve.
We didn't even talk about owner
And Eve.
agent
Yes,
as an advertising issue. We haven't brought it up. It just came to me lately. Is that something, I'm just asking the commission right now, is that something we ought to include in here so it's in black and white instead of people just working off Wendell's memory or my memory?
What's the law say?
Well,
Policy statement in it.
Ms. Maxwell, you want to fill us in, because to me, it's still confusing.
There was originally a rule that stated if you were selling a house to yourself and you were a licensee, that you had to put owner agent on your sign and alert individuals that you were an owner agent. When the rules that became effective in June of 2010 were passed, that particular section was taken out of the rule. So if you didn't know what the rule said before and you read them today, you would have no guidance, basically. There is a portion of the statute itself that requires a disclosure of a personal interest before entering into a contract. You have to get the written consent of all parties. And that's the fallback position for the owner agent, that it just has to be disclosed in accordance with the statute. But most licensees probably don't read that part of the statute and think, oh, owner, agent. They're thinking about other sorts of disclosures they might make, or if it's their mother or their aunt or some other relative. And so we do get a number of questions about exactly what an owner agent has to do. And I think a number of firms have policies, which probably leads to further confusion amongst the licensees. I don't know whether they do or not. I think they do, but I don't know.
But would it help the staff? Ms. Maxwell, if you could reference a rule that says you don't have to do it if your company doesn't think otherwise?
Probably be more clear to the licensees and to those who don't have reference to the old materials to sort of know, oh, yeah, that was taken out, so therefore, this is what I need to do, because I don't think most licensees look to that portion of the statute and think of it like that.
Like in this latest edition, does it say you have to?
The old
latest
one's still in there.
Yeah, it's
And
the latest edition.
It's the most recent also,
Well,
Yes. Well, no, but our pocket part,
which nobody has except
Well,
a few of us up here.
well, yes, but, the pocket part's on the website, but the pocket part has the new rules that were effective June the 6th of 2000, or June the 14th of 2010, and that removes that section. But reading through those rules, unless you were really conscious of that, you wouldn't know that something was removed. I mean, there's nothing that says deleted this portion.
So,
They in the new LexisNexis.
I know, yeah, but here's what I'm thinking. Under general principles, Wendell, if you look under general principle, they're just general principles. I don't know why we couldn't add a line in there that says there's no requirement from the Real Estate Commission that prior to entering into a purchase agreement, you have to advertise as owner agent.
That not only includes purchases, it includes rentals also.
All right, whatever. We're talking about intent right now, but I think it would make sense for us to go on record with something in black and white that says you don't have to do it if you don't have to do it.
Can I just ask for clarification on why that rule was put into place, what the logic behind it was? Because I wasn't a member of the commission then, so I really don't know why you wouldn't want owner agent on the sign.
It was because at some point, you've got to make a disclosure. And it was some on the commission, and it was pretty much a majority feeling on the commission at that time, that you did not need to put owner agent on a sign when you were disclosing at some point during the contract process that you had an ownership interest in this property.
I've had a few people contact me personally about this issue, stating that because of the way the rule is written now, they did not feel that that ever had to be disclosed, and it's causing some real problems down in the Chattanooga area.
You know, from my perspective, I'm real happy just to keep it like these guys say it is. But I'd just like to get it reduced to writing so that I can reference that you don't have to.
And we've had an issue.
I'm trying to get consensus here.
We've had an issue in that a realtor being a partner in a development. And so does that need to be owner agent if they're if they own part of a company that is a development company?
The only thing you have to do is disclose it when you write your contract, whether it's a lease contract or
And that's in a
purchase agreement.
statute. It's in 6213-4037A is where that is.
I just bringing it to a real life story. I just sold a piece of property that I personally owned about 4 months ago, and I had a sign on it for sale. I didn't have owner agent on my sign, but the people who called me, I told them, I said, I own this piece of property, and I disclosed right up front that I was the owner of it, and they could care less if I owned it. They wanted to buy it. And I sold it to them and closed on it about 3 months ago. So at some point, the statute says the rule, you have to disclose, but we said you don't need to put owner agent on the sign that's on the property.
Could you give me that rule number? What?
The statute that I
Yes.
was talking about, it's 6213-4037A. And that's just talking about prior disclosure of the interest and written consent of all parties. And that's the requirement as it stands right now, because with regard to selling your own property or someone else's that you have a personal interest in.
Can we reference that 6213-4037A and say you don't have to do it because of this statute? this section of the statute?
The statute's not saying you don't have to. That's the requirements for disclosure. It's not saying you don't have to advertise it that way. It's just saying what you must do, not what you don't have to do. So, and
Also, I'm okay with leaving it alone. I just thought I'd put this out here and see if there's
I just sort of worry a little bit about putting in there all the things you can do. You know, where do you draw the line then? I think the rule tells you the things you can't do. Maybe it may be something that might be worth putting in the newsletter or something like that, maybe getting the word out that way.
I'm cool with it. I'm comfortable now that I don't have to do it if I was selling my own property. But my company policy might supersede that as well. Okay, I'm done.
We have, thus far, we have discussed owner agent. We have eliminated section C and D from paragraph 2 of this particular rule. Does anybody want to make a motion that, as to the disposition of what we have?
I'll move that 1260.02-.12 as amended in paragraph 2 move forward in the rulemaking process. Second.
Commissioner Greaves has made the motion concerning this particular rule. Do I hear, and I've been seconded by Commissioner Alexander. Any discussion or questions or comments? Hearing none, all in favor say aye.
Aye.
Opposed, no. Rule 1260-02.12 has been approved. Move forward. Next we have.
And next is a new rule, which was put in here because it was formerly or is currently a policy. It's a new rule 1260-02-.39, commissions earned by affiliated licensees. And like I said, this was formerly or is a policy which in review was determined is better reflected as a rule, so it's merely put in there as such. So.
Mr. Chairman, I'll move 1260-02-.39 as currently written, move forward in the rulemaking process.
Second.
Commissioner Greaves has made the motion. You've heard it. It's been seconded by Commissioner Alexander. Any discussion on the motion pertaining to 1260-02-.39? Hearing none, all in favor say aye.
Aye.
Opposed, no. Move forward with that one. Next, Julie.
The next one is 1260-02-.40. It's a new rule entitled Electronic Records. Again, this is a policy that you all had adopted that would be better reflected in our rule. The same substance. I don't think this has been altered at all from the policy, so.
Chair, hear a motion?
I make a motion, we move forward with 1260.02.40.
Second.
Motion made by Commissioner DeShara and seconded by Commissioner Franks to move forward with this particular rule. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
And the last new rule is 1260-02-.41, entitled Licensees Who Hold Themselves Out as a Team, Group, or Similar Entity Within a Firm.
I make a motion, we move forward with 1260-02-.41.
Second.
Motion made by Commissioner DeShara and seconded by Commissioner Greaves. We move forward with this particular rule. Any discussion pertaining to this rule? Commissioner McMullen.
Julie, in paragraph number 1, where it talks about conducting real estate activities from the physical location of record of the firm, is that a requirement that is imposed on all licensees at all times?
That's a good point, because all real estate activities could mean showing a house, and that's, I'm not sure where this had come about from some prior discussions and some points that had come up and was included.
I think it was from I think the idea behind it was to prohibit teams from setting up their own little satellite offices and locations. And yeah, I mean, this is sort of all-inclusive, but that was the point, I think, that the commission wanted to stress.
Maybe that needs to be reworded to say something like, and must operate from same physical location.
Could say must operate from the physical location of the record, the physical location of record of the firm which they are affiliated. Because I agree with you that that's too all-encompassing, and sometimes it just takes somebody else pointing it out to realize it.
It's kind of hard to show a house at the office.
But don't some of these people operate out of their home?
Well, it couldn't be a licensed office out of their home.
If they have their license with the firm, they're still gonna have to, their main place of business is gonna have to be that
Office.
firm.
Some just show up occasionally.
But here's what I think. I think what we're trying to get to is a team that advertises itself in a different physical location than the license office that they're affiliated with. So like if you're working out of your house, Gary, you shouldn't be able to advertise your home address as your office.
Right.
I mean, that's what we're trying to get to. That's the intent.
Maybe
But it says that I must conduct all real estate activities there.
But we've conceded that. I think that we're just trying to, the point is to make sure there's a base of operation that's the same base as the company you're affiliated with in some form or fashion.
Not a satellite office at a subdivision that wants to have a broker or something like that.
So rather than saying where they have to do whatever, would it make more sense to approach it from the other way to say something like, no team shall, like John's saying, maybe advertise, a different location from the firm?
What about
effectively?
no team, group, or similar entity within a firm may establish a physical location separate from the physical location of record of the firm with which the members are affiliated?
Yeah, that's what we're trying to
As
say.
long as you started to preface it by saying licensees who hold themselves out as team. I don't want to get in a position where we're going no team because it actually causes some credibility to be passed on from this commission.
Okay.
So if you're consistent with the language you used otherwise, I think that's fine.
Could you clarify what you just said?
There's nowhere in the statute, nowhere in our rules and regulations that gives any credibility to a team.
I agree with that.
Okay, so I just asked that Julie, who quickly was paraphrasing what we'd said up here, said no team shall, and I want to make sure it says licensees who hold themselves out as a team. That's their term.
Okay.
Should you, to John's point then, should you do the same thing on number 4, where it says neither the team, group, or similar entity nor its members shall represent them itself? Do you want to say the same thing there?
Absolutely.
Can I just read back one first before we move on to
Sure.
the next
Sure.
one to make sure I've worded it
Yeah.
correctly? As I've taken from your comments just now, no licensed member of a team, group, or similar entity within a firm may establish a physical location separate from the physical location of record of the firm with which the licensee is affiliated.
I
I think
don't
so,
like the
but I
start
don't
of it.
think John would like the beginning.
I don't like the beginning at all.
Yeah, hold themselves out.
Licensees who hold themselves out as a team, group, or similar entity, and then plug in whatever you want to after that. But I really don't want to acknowledge a team as being anybody we officially recognize.
Okay, so then to
They
say
might
no licensee who holds,
Just say,
I'm sorry,
Yeah, no, I think that you're starting off right.
Yep.
Right there. Keep going.
no licensee who holds, I guess it would be his or herself out as a team, group. No licensees who hold themselves out as a team, group, or similar entity within a firm may establish a physical location separate from the physical location of the firm with which they are affiliated.
I wouldn't start with no. I would just say licensees who hold themselves out as a team, group, or similar entity must be affiliated with the same firm and cannot establish whatever you said at the end then.
and may not establish a physical location separate from the physical location of record.
That's perfect.
And may not. To read it back
Yes,
again?
please.
Okay. Licensees who hold themselves out as a team, group, or similar entity within a firm must be affiliated with the same license firm and may not establish a physical location separate from the physical location of record of the firm with which they are affiliated.
Move
Got it.
on.
Okay, I've got the notes for that one. Okay, 4. I'm sorry to have interrupted. I wanted to make sure I had that one correct before we moved on.
Now let's look at number 4. And I think maybe you need to say something there like, no licensees who hold themselves out as a team, group, or similar entity within a firm shall represent themselves as a separate entity from the licensed firm.
Okay. Everyone else in agreement with that before I... Okay.
What about numbers 2 and 3 as far as that concept of licensees who hold themselves out as opposed to saying pay every licensee on any team, or in number 3 to the leader of any team?
Always needs to have that, who hold themselves out to cover us so that we're not giving our blessings there.
Austin, what about the may?
Which one?
In 2, only a licensed principal broker may pay, must pay. He's the only one can do it. May is if someone else could do it too, isn't it?
So would it be accurate to flip it around the other way and say something like, no licensees who hold themselves out as a team, group, or similar entity within a firm shall accept any compensation except from
The licensee's
the
principal broker.
licensee's principal broker? Would that be accurate?
Julie, did you get that?
I think so.
I think she may be listening to this tape next week again.
I'm trying to get it down where I don't have to do that and to make sure I really understand it.
I hope you'll take your time. We're not rushing you on this.
No
We wanna get it right.
licensees who hold themselves out as a team, group, or similar entity within a firm did you say may receive compensation from anyone other than the principal broker? Shall not receive compensation. Shall not receive compensation from anyone other than the principal broker, from their principal broker. Okay, so no licensee licensees who hold themselves out as a team, group, or similar entity within a firm shall not receive compensation from anyone other than their principal broker.
Double negative in there somewhere. Just ask.
Julia
Was
cleaned
it
it
double
up.
negative or double entendre? Which one was it?
As great a command of the English language that Julie has, she'll word it properly.
So
Just out of curiosity, while she's writing on that, I've been primarily for the last 20 years involved in real estate auctions, and I haven't been keeping up with what's going on out there in the real world. When did the concept of teams begin in this industry?
Been around ever since I've been in business. I've been in business 16 years, so.
16 years
Yeah,
ago.
it wasn't any longer than that. I don't
It's
think.
not my fault, Wendell. Now, there were only a few when I got in the business in our area, but I think some of the larger areas, it had already gotten to be a big thing.
Not yet.
Not yet.
I got number 5 to go yet, too.
Okay, I think I've got 2 down. No licensee who holds themselves out as a team, group, or similar entity shall receive compensation from anyone other than their principal broker.
Can we look at number 3?
Let me just mention one
Yeah.
thing about that. The only problem I've got with that is I'm always anxious to put the onus on the principal broker, not the affiliate. And that's what bothers me about not saying the principal broker cannot or shall not, as opposed to the affiliate receiving payment. That's just a thought. I mean, the intent is there. And I think somewhere else we've got in our statute that says only the principal broker can pay an affiliate, so that might just be too
The
much.
burden's on the principal broker, not the agent or affiliate. Responsibility.
Really, the feedback we've gotten is that there are team leaders who are just collecting payment from the principal broker and then subdividing the check into other licensees, which is
Illegal.
Clearly a violation of the statute now.
As the statute is now for anyone, 6213, 312B11 appears to me to put the burden on the person not to accept the compensation from anyone. I can read it to you other than the principal broker
I'll take it.
because
If that's your interpretation, I'm very happy with the way you just read it.
because the violation there, and I'm summarizing this, is accepting a commission or valuable consideration by an affiliate broker for the performance of acts specified from anyone except the licensed real estate broker with which they are
Let's move on.
affiliated.
Let's move on.
So, I think that's in similar keeping with
Perfect.
the statute.
Paragraph number 3. Can we rephrase that to say the principal broker shall not delegate his or her supervisory responsibilities to any licensees who hold themselves out as a team, group, or similar entity within a firm,
Okay.
as the principal broker remains ultimately responsible for oversight of all licensees within the principal broker's firm?
Just use that language from the title of the rule in that part and take out to the leader of the team, group, or similar entity within a firm and say any licensee holding themselves out as a team, group, or similar firm, or
Yes,
similar
ma'am.
entity within a firm.
Yes, ma'am.
I see, I understand.
Commissioner McMullen, you want to address number 5?
Number 5, would the commission be satisfied if it said, no licensees who hold themselves out as a team, group, or similar entity within a firm shall designate members as designated firm agents, as this remains a responsibility of the licensed firm's principal broker?
I might just change it a little bit and say, have the authority to designate. So read your first part, and then where you said, I think, shall.
No licensees who hold themselves out as a team, group, or similar entity within a firm.
I would go, shall have the authority, or have the authority.
Well,
Oh,
what
okay.
if we just say they shall not?
Well, either way, I'm just.
Well, if you say no at the beginning, we would say shall.
Yeah, right.
So.
Yeah, no shall.
It's the same thing.
You cannot argue with 2 attorneys,
Thank you.
Commissioner Greaves.
No, I
don't have a problem with that wording. I was just saying we don't want to.
We can, but he won't win.
So.
I've been known to dabble in the unauthorized practice of law, so.
Uh-oh.
I deny that.
You heard it here. You got that on record. That's not good, John.
Is there anybody else with any comments?
Motion to approve.
As amended, I guess.
We had, definitely as amended, as tweaked, should we say. Commissioner Collins makes a motion that,
John wanted to tweak 5.
We just did.
we just did. But anyway, Commissioner Collins has made a motion that we move forward with 1260-02-.41, and it's as tweaked and as,
That's actually a friendly amendment.
that's a
Regarding it.
friendly amendment. Anybody have any other discussion or comments on any of these
One of my
5?
friends.
Hearing none, all in favor?
Who seconded?
Second, who makes that?
Second.
Oh, Commissioner DeShar, Commissioner DeShar. Commissioner Franks, thank you for bringing that to my attention. Anyway, Commissioner DeShar seconded that motion. Any other comments or discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. We're moving forward.
Okay. The next thing that we need to do, and I passed you a memorandum as a jumping off point for consideration, is complete the regulatory flexibility analysis, which under Tennessee Code Annotated Section 45402B, that review must be conducted prior to initiating the rulemaking process, and I've outlined each of the considerations. I've included a statement that I've drafted as a jumping off point for discussion, but you all should, we're going to consider each one and adopt a statement in response to each one of those. The first one is the extent to which the rule may overlap, duplicate, or conflict with other federal, state, or local governmental rules.
Commissioner McMullen,
I move that we adopt the following statement with regard to Part 1 of the regulatory flexibility analysis. With respect to the rules proposed, there will be no known overlap, duplication, or conflict with other federal, state, or local governmental rules.
is there a second?
Second.
Second by Commissioner DeCharo. Is there discussion on the motion?
Call for the question.
Hearing no discussion, let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. It's unanimous.
Second
Ms.
is,
Crop,
I'm sorry, did somebody say something?
you go. I'm sorry.
Second one is clarity, conciseness, and lack of ambiguity in the rule.
Mr. McMullen,
Respect to the second point of the regulatory flexibility analysis, I move that we adopt the statement that the proposed rules are clear, concise, and unambiguous. Further, the proposed rules are not open to different interpretations.
Second.
seconded by Commissioner DeCharo. Any discussion? Hearing none. All in favor of the motion, vote aye.
Aye.
Those opposed, no. It is unanimous.
Number 3, the establishment of flexible compliance and reporting requirements for small businesses.
Mr. McMullen,
Mr. Chairman, with respect to the third prong of the regulatory flexibility analysis, I move that we adopt the statement that these proposed rules provide uniform and reasonable requirements both for licensees of the Tennessee Real Estate Commission as well as those individuals who wish to be licensed with the Tennessee Real Estate Commission. The proposed rules assist with ensuring the welfare and safety of the citizens of Tennessee.
is there a second?
Second.
Seconded by Commissioner DeCharo. Is there discussion on the motion? Hearing none. All those in favor of the motion, vote aye.
Aye.
Those opposed, no. It's unanimous. Ms. Crop,
Number 4, the establishment of friendly schedules or deadlines for compliance and reporting requirements for small businesses.
Mr. McMullen,
Mr. Chairman, with respect to the fourth prong of the regulatory flexibility analysis, I move that we adopt the following statement. The proposed rules will not be effective until a rulemaking hearing is held, which is open to the public for comment, and 90 days have passed after filing with the Secretary of State any rules which are adopted by the Tennessee Real Estate Commission at said rulemaking hearing. Therefore, any individuals affected by these rules will have notice and an adequate period of time to ensure compliance with the requirements of the rules. Furthermore, the schedules and deadlines contained within the rules are friendly for various compliance and reporting requirements.
Thank you, Mr. McMullen. Is there a second?
Second.
Seconded by Commissioner DeCharo. Is there discussion on the motion? Hearing none, all those in favor of the motion vote aye.
Aye.
Those opposed, no. It's unanimous. Number 5, Ms. Crop.
Number 5 is the consolidation or simplification of compliance or reporting requirements for small businesses.
Mr. McMullen.
Mr. Chairman, I move that we adopt the following statement with respect to the 5th prong of the regulatory flexibility analysis. The proposed rules, some of which amend current rules and some of which are new rules, are intended to provide clarification and are not intended to or expected to complicate compliance or reporting requirements for small businesses.
Is there a second to the motion?
Second.
Seconded by Mr. Charo. Is there discussion on the motion? Hearing none, all those in favor of the motion vote aye. Aye. Those opposed, no. It is unanimous. Number 6.
6 is the establishment of performance standards for small businesses as opposed to design or operational standards required in the proposed rule.
Mr. McMullen.
Mr. Chairman, with respect to the 6th prong of the regulatory flexibility analysis, I propose that we adopt the following statement. Many of the proposed rules do not include design or operational standards. Any rules involving design or operational standards, such as the rule amendments to the escrow and trustee account rule and the advertising rule, incorporate such standards in order to ensure the health, safety, and well-being of the citizens of Tennessee, which it is not believed could be adequately accomplished through the use of performance standards.
Second to the motion.
Second.
Seconded by Mr. Charo. Is there discussion on the motion? Hearing none, all those in favor of the motion vote aye.
Aye.
Those opposed, no. It is unanimous. Number 7, Ms. Crop.
7, the unnecessary creation of entry barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs.
Mr. McMullen.
Mr. Chairman, with respect to the 7th prong of the regulatory flexibility analysis, I move that we adopt the following statement. The proposed rules do not result in the unnecessary creation of entry barriers or other effects that would stifle entrepreneurial activity, curb innovation, or increase costs.
For a second.
Second.
Seconded by Mr. Charo. Is there discussion on the motion? Hearing none, all in favor vote aye.
Aye.
Those opposed, no. It is unanimous. Ms. Crop.
There are a few other considerations that are part of, not part of the regulatory flexibility analysis, but should be considered at this time. The first one is, does the rule make it better to do business in Tennessee?
Holland.
Mr. Chairman, I propose that we adopt the following statement. The proposed rules do make it better to do business in Tennessee because the proposed rules are expected to make it the proposed rules will be clarifying the requirements for licensees of the Tennessee Real Estate Commission in order to ensure the welfare and safety of the citizens of Tennessee.
Is there a second?
Second.
Seconded by Mr. Charo. Is there discussion on Commissioner McMullen's motion? Hearing none, all in favor of the motion vote aye.
Aye.
Those opposed, no. It is unanimous. Ms.
Does the
Crop.
rule make it better? Does the rule make it easier to create jobs in Tennessee?
Mr. McMullen.
Mr. Chairman, I move that we adopt the following statement. The proposed rules are unlikely to have a foreseeable negative impact on job creation in Tennessee.
Second.
Seconded by Mr. Charo. Is there discussion? All those in favor of the motion vote aye.
Aye.
Those opposed, no. It is unanimous. Ms. Crop.
Is it essential and effective?
Mr. McMullen.
Mr. Chairman, I move that we adopt the following statement. The proposed rules are essential and effective as they seek to clarify the responsibilities of licensees and applicants for licensure in order to better protect the welfare and safety of the citizens of Tennessee.
For a second.
Second.
Seconded by Mr. Charo. Is there discussion? Hearing none, those in favor of the motion vote aye. Aye. Those opposed, no. It is unanimous. Ms. Crop.
Effect.
Mr. McMullen.
Mr. Chairman, I move that we adopt the following statement. The proposed rules affect licensees of the Tennessee Real Estate Commission, some potential applicants for licensure, as well as citizens of the state of Tennessee.
Is there a second?
Second.
Seconded by Mr. Charo. Is there discussion on the motion? All those in favor of the motion vote aye. Aye. Those opposed, no. It's unanimous. Ms. Crop.
Is the rule a positive move?
Mr. McMullen.
Mr. Chairman, I move that we adopt the following statement. The proposed rules are a positive move. These proposed rules seek to further specify the responsibilities and duties of licensees, as well as clarify existing rules in order to protect the welfare and safety of the citizens of the state of Tennessee. Also, the military applicant rule seeks to streamline the application and renewal process for affected individuals.
For a second.
Second.
Seconded by Mr. Charo. Is there discussion on the motion? All those in favor of the motion vote aye. Aye. Those opposed, no. It is unanimous. Ms. Crop.
Is it outcome-based? Does it have a measurable positive outcome?
Commissioner McMullen.
Mr. Chairman, I move that we adopt the following statement. The proposed rules are outcome-based and will have a measurable positive outcome. The Tennessee Real Estate Commission expects to receive fewer questions regarding the responsibilities and duties of licensees, as well as clarify some of the existing provisions found within the statutes and rules of the Tennessee Real Estate Commission.
Is there a second?
Second.
Seconded by Commissioner DeCharo. Is there discussion? All those in favor of the motion vote aye.
Aye.
Those opposed, no. It is unanimous. Ms. Crop.
And I know that you all had voted to accept the language as it was for each of these, but just for clarification purposes, at this point, if we could have a motion by the commission to move forward with the rulemaking hearing based on the drafted rules as we have amended them here today, if we could just have a concise one at the end, that would be, I think, good.
Motion to move forward with the drafted rules as they have been amended and proposed today.
Is there a second?
Second.
Seconded by Commissioner DeCharo. The effect of this motion, Julie, if it passes, is what happens next?
The next step of this is that I will create a memorandum that has to be circulated through the legal department up through the assistant commissioner for review. Then it is all rules now before a rulemaking hearing are pre-reviewed by the Attorney General's office for legality. It also has to be reviewed by the governor's office. Once all of those parties have reviewed it, I then file a notice of rulemaking hearing. It's approximate 50 days that it has to be on file with the Secretary of State's office. Notification is sent out via the notification app to any licensees that have signed up for that. And after that point in time, we hold a rulemaking hearing. And at this point in time, I can't give you an exact month of when that'll be because it requires certain steps of approval, but I will be diligent in following up and ensuring that this gets approved as quickly as is feasible with the number of people that need to review it.
Thank you. Is there any discussion, other discussion or questions? Hearing none, all in favor of the motion vote aye. Aye. Those opposed, no. It is unanimous. Now, that concludes this portion of the rulemaking hearing. Am I right, or is there anything else?
That's all that's left, and there's 15 minutes before lunch. There was one miscellaneous item I was going to bring to your attention.
Let me just make one quick statement. This, for attendees and for commissioners, this commission over the last several months with the help of staff has worked diligently to try to get these rules in position to move forward. And it's not been a casual discussion, and so some of you guys sitting in the audience today, maybe 6 months from now, these may become effective, plus or minus a month or two.
It won't be effective in 6 months, I don't believe, because we have to have the rulemaking hearing, which could take several months before that takes place, and then it's again reviewed by the Attorney General after the rulemaking hearing. Then it has to be filed with the Secretary of State. I believe it's 90 days before they become effective.
My point is, this has been a long, long process, and we've got a ways to go. And nothing we did today was more than just keep it moving. Is that the proper way to say it?
We're formally starting the process today.
Thank you very much.
So.
Back to you, Chairman Stevenson.
I think I may just resign, just go ahead and let you continue on.
We couldn't be that lucky.
Okay. Now, is the next thing, the other thing is your legal report, but you have one other thing.
There's something that came up yesterday. Actually, we do have a bill that came through, and I completed a bill analysis on yesterday, so it was after we'd already done the agenda. I was going to pass out a copy of it to each of you and just briefly give you a description of it. At this point, all that's been done is that it's been filed, but I wanted to give this to you at the meeting.
Okay. I know, Steve, how long will your report take? you think?
It's up to you. There's like 3 things up for discussion.
The reason I was asking Steve about his education report,
I really won't take long, Chairman.
after we look at this, rather than depending on how long this discussion takes, so we can break by 11:30, we could do yours before we get into the legal report.
That sounds good. My concerns on my report are detailed in the comments at the very last.
Okay, okey-doke. Now, what do you have to share with us, Julie, on this bill that's been?
Well, I passed out a copy of the bill to you. It was introduced by William Lamberth. It's my understanding I believe is from Sumner County. This was filed on January 3rd, 2014, and at this point, that's all the action that's been taken. But in essence, this amends a section, a code section found within the statutes pertaining to the General Sessions Courts, and it amends it by stating that a real estate broker may file an interpleader action without attorney representation as long as the broker or the real estate firm is not claiming any right to any portion of that money without that constituting unauthorized practice of law in violation of 23.3.103, which is actually the statutes pertaining to attorneys. But since we have a provision within the Brokers Act, within 6213.312, it's particularly B19, which allows the commission to take disciplinary action for engaging in the unauthorized practice of law. I believe if this is legislation that is passed and signed into law, that would be something that this particular set of circumstances would no longer be considered the unauthorized practice of law as it pertains in our statutes too. So I wanted to make you aware of it. Like I said, all that's been done at this point is that it's been filed. I'll keep you updated on it, but it just came through, so I wanted to make you aware of it at this meeting.
Okay. Does anybody have any questions or comments pertaining to this law that has been dropped into the hopper?
I'll keep you posted. I
Okay.
just wanted to, since it just came down, make you aware of it. So.
Okay, thank you, Julie. Since,
And I think Robin did have an update about formal hearings. I don't know if she wanted to share that now, or if somebody else has something they want to do. I don't know.
Ms. Ryan?
There was to be a formal hearing tomorrow, not before you, but before an ALJ alone. This was a matter that was continued from last November to tomorrow's date. It has been continued again. My plan is to have this hearing before you as the commission next month on the second day. I just wanted to give you an update that there will be a hearing on that day next month.
Okay. Thank you, Ms. Ryan. It's 19 after, and I think before we get in, start the legal report, and have to suspend and break for lunch, we could go ahead and have our educational director, Mr. Steve McDonald, bring us his report.
Hey, thank you, Chairman. There are, if I can get my iPad to cooperate, there are 16 courses that have been reviewed and do meet rule. I didn't have any questions or concerns about them. Do you have anything or any questions for me before we go to the courses requiring discussion?
Mr. Chairman, I'll move that courses J1 through J16 be approved.
I'll second.
I have a motion by Commissioner Grease and second by Commissioner DeShar that courses J1 through J16 be approved. Any questions or comments on any of these courses? Hearing none, all in favor say aye.
Aye.
Opposed, no. Courses are approved. Now, we've got courses requiring discussion.
Thank you, Chairman. It's raining reverse mortgages. It seems like it's been a topic for the last several months. J17 and J18 are the same courses. They are put before you by two different providers with the same instructor. The comment that I've made for both of these is this course discusses the characteristics of the senior population and the mortgage products available to them for purchasing or refinancing a home. Reverse mortgages are included in the coursework, and the course provides the pros and cons of this financing type. Of the 3 hours total for the course, 70 minutes on the outline are devoted to the topics of reverse mortgages. So, do you wish to approve or deny this course?
Just out of curiosity, a 3-hour course has how many minutes in it? 150, so half the course is reverse mortgage, basically. I'll move J17 and J18 be approved.
Second.
Have a motion that J17 and J18 be approved. The motion made by Commissioner Grease and seconded by Commissioner Franks. Discussion on the motion.
No, I'm going to vote against.
Any?
Come on.
Commissioner Alexander, when did that stop you before?
Yeah, he's generally preaching all the time.
I know it. You usually.
Don't encourage him.
Yeah. Any other discussion or comments on J17 and J18?
Has anybody reviewed it besides you, Steve?
No, sir.
Got any recommendation?
Having listened to the discussions of reverse mortgages for the last several months, it does contain a fair amount of topic on reverse mortgages, and it has been the Commission's stance not to approve courses that had reverse mortgages, but I'm bringing them to you every month with the discussion. We have a request in from the AG's office to come and talk to us about reverse mortgages, and at this time they do not have anything scheduled with us, with me to present to you.
But this one does, this course does have the pitfalls.
The pros and cons, correct. There is an element that talks about the negative effects of a reverse mortgage.
Office reviews it.
I can't make that determination.
What's your suggestion?
It was suggested by Commissioner Haynes that we bring someone in from the AG's office to discuss this topic, and I will work diligently to uphold your decision.
Chairman, I move that this be deferred until we have that opportunity to approve those two courses.
Substitute motion of the original motion to approve to defer until we have a representative from the AG's office come and talk to us about this topic. Have you had any?
Gotta have a second on that.
And we got to have a second on it, on Commissioner Alexander's substitute motion to defer.
I'll second it.
Commissioner Collins' discussion has seconded that motion. Have you had any discussion, Steve, with the AG's office?
Just their front point of contact when you call, and they do tend to warm up when they know that it's another commission body calling in. I did call over the holidays, so there is maybe some of that involved with the delay in scheduling a future meeting. Did that answer your question? I'm trying not to talk in circles.
Yeah, I understand, but do you think you possibly, by next month, will have some discussions, some contact, further contact with AG's office so we can move forward with making a decision on J17 and J18?
I will make sure that my communication is stressed that you all are very interested in hearing them, and this doesn't have to be a lengthy discussion from them, but I will, if we adjourn or if we recess this afternoon before they close, I will make contact, if not first thing in the morning, and I'll follow up with every one of you by email.
Okay. Any other discussion on Commissioner Alexander's motion to defer? Hearing none, all in favor of Mr. Alexander's motion, substitute motion to defer this until we hear from the AG's office, say aye.
Aye.
Opposed, no.
No.
Roll call vote.
You want me to call it?
Yeah, call the roll. On the motion to defer that Mr. Alexander made, and seconded by Commissioner Collins.
Flitcroft, absent. Franks?
No.
Alexander?
Oh,
No, no,
Wait, this is a motion to defer.
are you voting yes for your
yes,
motion?
yes.
Could you do this in alphabetical order?
No, you know what that does to her.
I watched myself do that on the tape from last month. It was kind of grim. Okay, so Alexander,
I'm gonna vote yes. I'm gonna vote for my motion. But
just wanted to make
you can call
sure.
it off because it's gonna fail.
McMullen?
No.
Bloom?
No.
Collins?
Yes.
Grease?
No.
DeChara?
No.
Stevenson?
Where are we?
You can make a safe vote.
We voted.
Two that are in favor of the motion to defer, and 5 who are not in favor of the motion to defer.
I'm going with the majority. I vote
That's a
no.
principal vote right there.
You vote what? You vote no? Okay. So the motion fails 6-2.
So now we're back to the motion, to John's motion.
Now, John's motion and seconded by, I think, Commissioner Collins seconded.
No,
No, it's Shar.
I did.
DeShar, okay, Janet.
Or Commissioner Franks, maybe.
Okay, which is to approve, of course, J17 and J18. Any other discussion? Hearing none, all in favor say aye. Aye. Opposed, no.
No.
Let the record show it passed 7-1. 6-2. Okay, 6-2.
And where was your vote there, Mr. Chairman?
I'm in at 6.
Yeah, okay, just checking.
I'm in the majority again.
And still invite the AG's office, or no?
Yeah, still. Yeah, we'll get them
See how
down here.
quickly they can get here.
Commissioner Collins. Commissioner Collins was a no. Okay, what about J19?
I don't see why we need the AGs anymore now if we've already done it anyway.
Well,
That's
they
a
can-
waste of time, isn't it?
They can enlighten us some. We might have some other questions we want to ask somebody.
Okay, J19. The question comes with Monica Wilder's experience. Ms. Wilder holds a broker license 306093 and requests approval for teaching pre-license course without 5 years of experience as broker. Her post 120 hours runs from October 22nd, 2013 until October 21st, 2016, and she has been actively licensed since September 19th, 2011, and completed pre-license in 2006. She does hold a BBA business degree in finance, real estate, and mortgage experience since 2004. It has been the precedence of the commission not to approve pre-licensed instructors who do not meet that 5-year requirement.
But she just got her broker's license and hadn't even completed her education.
Correct. She's still working on her post 120.
I make a motion we not approve Ms. Wilder for this course.
Second. That's J19. Of course, J19. A motion by Commissioner DeShara not to approve, and seconded by, I think, Commissioner Franks seconded this motion. Any discussion on the motion to deny this course?
Mr. McDonald, if you would, please let her know that the reason is she just doesn't have the experience needed
Yes, ma'am. Will do.
to teach that course.
Any other comments or discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously.
Okay, the instructor approvals is my last item of business. I have one that is submitted before you. It's Sally Cummins of TAR, provider 1110, requests the approval of Larry Carroll to teach the ABR Day 2, that's approved course 7177, and the senior real estate specialist, is course number 5367.
You're recommending approval?
Approval, yes, sir.
Motion to approve.
Commissioner DeShara makes a motion, we approve Sally Cummings as an instructor.
Larry Carroll.
Larry Carroll, I'm sorry. Larry Carroll is instructor, and seconded by Commissioner Collins. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries unanimously.
It's 11:30.
Is this your report in its entirety?
Yes, sir, it is.
Let the record show, it's exactly 11:30. Time for our
Good job, Steve.
our break.
We're eating.
And
The pub.
you licensees,
The
you
pub.
be back here at 1 o'clock, along with all the rest of us.
Pub.
We call this regularly scheduled January commission meeting back into session. Next on our agenda is an informal applicant appearance, but with Charles Zachary Doak, who is the applicant, and Randall Fuller, his principal broker. If you two would come up here and sit over here in these first two chairs. And Ms. Kropp will swear you in.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
And I'd like to ask you if you would pull that microphone back over there close to you, and when you talk, lean over and talk loudly into that microphone.
Sir.
We're old and came here.
Do you want me to go on?
Okay, Ms. Maxwell, yes.
Charles Zachary Doak is here today. He would like to be an affiliate broker. He has tested. He's with his principal broker, Randall Fuller. Mr. Fuller is the principal broker of Blackwell Realty and Auction. Mr. Fuller was first licensed as an affiliate broker in 1986, and he became a broker in 1989 and has been a broker and principal broker off and on since 1989, and he has had no complaints filed against him. Mr. Doak has disclosed that he has a misdemeanor theft of property under $500 conviction, which occurred in 5/16 of 2006. The actual events occurred when he was 21 years old and worked as a bartender at Ruby Tuesdays, and he's told the commission that he gave drinks away to his friends who came to the restaurant. He got caught, and he made restitution of $2,353.29. He was on probation for 11 months and 29 days, and that probation ended on 5/15 of 2007. Now, Mr. Doak has been a bartender at Chili's. I don't know if he still is, but he's been a bartender and server there. He says that he has joint custody with his sister, with her children who are 9 and 7. He had full custody while his sister was incarcerated of her 2 children, and he also has a child of his own now and would like to enter the real estate business. And I'll let you fill in any gaps that I missed.
Just, Mr. Doak, if you would, just in your own words, tell us a little bit about your situation that causing you to have to come before this commission and why you'd like to get a real estate license.
Well, as she mentioned, I was 21, and I don't think I had much direction at that time. Really didn't think there'd be, many consequences of, the actions I was taking there at work at Ruby Tuesday, and I just think I was just, young and wasn't really thinking ahead there, and realize now that, I knew at the time, it was wrong, but do realize now that, how costly it could be and still can be. And I think I've, moved past that point in my life, and I've had a lot of life experiences over the last couple of years, and particularly, as she mentioned, taking custody of relatives, and now actually having a family of my own. And I just, I want to, just, I guess, be a good example and be, fulfill my own potential, what I expect for myself. I don't really want to work in the bar business forever, and just always been interested in real estate, and finally decided to take a chance and act on it and see what I can do, actually.
Any commissioners before we hear from his principal brokers, any commissioners have any questions they'd like to ask of Mr. Doak?
Just one point of clarification. I think Ms. Maxwell mentioned a theft of $500.
Yes, sir.
The paperwork looks to me like it's $1,000 to $10,000, or what's the discrepancy there?
The initial charge was, the felony charge, which was $1,000 to $10,000. They actually got was able to drop that down to the misdemeanor, under 500.
Did you plead guilty to that?
Yes, sir.
Okay, thank you.
And I did. I actually, the restitution was paid in full, before any of the, before I even appeared in court. And, but yes, I did actually plead guilty and was just able to get a bargain there.
Any other commissioners have any questions of Mr. Doak? If not, then Randall Fuller.
Yes, sir.
Tell us a little bit about your company, how long you've been in the business, and what kind of a training, mentoring program are you going to have for Mr. Doak if this commission decides to grant his entering this industry?
Well, I've been in the business since, I believe it was 86, 87, got my affiliate license and got my broker's license in 89, and I've been full-time in real estate the whole time. As far as Mr. Doak, mentoring, we have weekly meetings on Thursday, sales meetings. We'll go over contracts, agency, different things like that, listings, and, I'll just, any questions that he might have, I'll be there to answer. We're there at the office every day, I am, so.
How many agents?
We have approximately 30, I believe. Most of them are part-time, probably about 10 that are full-time.
I have any questions of Mr. Fuller?
I make a motion, we approve Zach to move forward and get his real estate license.
Second.
We have a motion by Commissioner DeShara and seconded by Commissioner Franks that we grant Mr. Doak the license that he wants to get into this industry. Is there any discussion on the motion? Any comments? If not, all in favor say aye.
Aye.
All opposed, no. Motion has passed 8-0. Unanimous vote, Mr.
you.
Doak. Good luck. And as it has been said before in years past, if you come back, Mr. Fuller will come back.
Just out of curiosity, how did the amount of restitution, how did that amount arrive at? Were they watching you the whole time, every time a drink went out, or how did Ruby Tuesdays keep track of that? Not that I'm interested.
He's thinking about a second career here, Zach.
You want to be a bartender?
I might know a bartender.
It's a trick to the trade, and I don't know that I need to disclose that. I'm just kidding. It was just pretty much an estimate that I came across with the area director, just estimating, what I was doing on a regular basis for, I think, the year that I worked there.
You were a pretty generous guy. I hate you weren't my friend.
I still do it in Lebanon at Chili's, so come on down and get a drink.
You still bartend, you said. Okay.
I think, Mr. Doak, good luck,
Thank you.
and we wish you the best.
Appreciate it. Thanks. Thank you.
Next on our agenda,
We're going back to Miss Crop.
we're going back to Ms. Crop, who is going to finish up her legal report with our
Legal report.
legal report.
Yep. That'd be a
Okay.
good place to start.
Remember change you can, Judy.
What'd you say?
I say happy member change you can.
Oh. All right. I'll begin by reading the statement at the beginning of the report. Any consent order authorized by the commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. I want to start out with one that's not on this report. I'm going to read to you from last month because I was asked contacted several times by the respondent who had additional information and asked that I at least present the additional information to you all to see if you would reconsider what you had authorized last month. I'm going to read the original report, provide you with the information that I was given, and you can either stand by your original decision, or if you'd like to change it, you can do so. I'm just doing so because I think that there was sufficient enough information here to warrant representation. So I'm going to begin with that one because I'm worried if I do the whole report, I'll forget to
As a
come back.
rule, don't they have a right to appear before us anyway?
Ever since I've been here, it's either been the consent order or it goes forward to a formal hearing.
Well, I mean, if they didn't agree, they could come back and appeal directly. Is that not true?
Since I've been here, that opportunity has been in the format of a formal hearing when they've done
I mean,
it.
they can ask for a formal hearing.
Correct, but there's some information that, wasn't in here the first time that I was going to just provide you all with, and like I said, you can keep the original decision or change it and say, no, we're going forward as is, but I told this person in light of the information that I would at least present it to you all for a determination.
Oh, we go through this about every month. Somebody sends us additional information. I believe when I was in trouble, I get you all the information you want on to go for it.
I don't believe I've been giving them to you every month. I did it a couple
No,
months ago.
I'm not talking about you. I'm talking about, Julie, I'm talking about the people that the complaint.
There's a lot of people that claim to have more. This is some information that we did not have the first time. Sometimes I will tell the individuals when they say I have additional information, I'll tell them it's not enough to warrant representation. This one I thought might possibly warrant that. If you don't wish to hear it, then that's fine. But I did say I would bring it before you, so.
I think if you said you're going to bring it to us, you ought to do that.
Well, I mean, if you don't want to rehear it, though, I can at least say I gave the commission the option. They did not want to rehear.
Move to allow council to present the new information to us.
I'll second that.
Have a motion by Commissioner McMullen, second by Commissioner Jashara, that we move forward and let Ms. Crop present the new information that she has on this complaint that we heard last month. Any discussion on the motion?
One question, just before I vote. So I was involved in one last month.
It's not that
Okay.
one.
Any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no.
Okay.
Pass.
Commissioner Collins passes.
Okay, the complaint number is 2013-013981. The complainant is the designation coordinator for a real estate organization where respondent, a principal broker, was formerly a member. Complainant states that the respondent had formerly earned a designation through complainant's organization, but states that respondent discontinued respondent's membership several years ago. Complainant states that respondent continues to use the designation and states that complainant has contacted respondent 3 times asking respondent to either discontinue using the designation or reinstate the membership. Complainant also provided copies of multiple written requests made by complainant to respondent, which were sent prior to filing the complaint and which notified respondent of respondent's expired designation and provided information regarding reinstating the membership or instructed respondent to stop using the designation if the respondent chose to remain inactive. Complainant also attached screenshots from websites in which the designation was utilized while respondent's membership was expired. The screenshots note the designation along with respondent's name and other information. Respondent submitted no response to the complaint, which was sent to the firm address on file with the commission and signed for by an individual there. The complainant later sent additional information stating that respondent contacted complainant and resolved the issue by reinstating respondent's membership, so respondent is now entitled to utilize the designation. The recommendation at that time was a consent order for $1,500 for failing to respond to a complaint filed with the commission in violation of Tennessee Code Annotated Sections 6213-312B14 and 6213-313A2. and misleading or untruthful advertising in violation of Tennessee Code Annotated Section 6213 312B4, plus attendance by respondent at one entire regularly scheduled meeting of the Commission within 180 days of respondent's execution of the consent order. At that time, the Commission voted to accept the recommendation, and a consent order was drafted and sent to the respondent with that. The individual contacted me and stated that when the respondent received a copy of the complaint, the respondent immediately contacted the complainant, which in this case was a real estate organization that provides designations. It's a prestigious real estate designation organization, and at that time was told if the respondent paid the money to reactivate the membership, that the complainant, that organization, would contact TREC and take care of everything. That person states that that's the reason why they did not submit a response to the complaint. Now, I pointed out to the individual that in the letter from our complaint coordinator, Mr. House, that goes out with all complaints, that it says you must send a sworn, I'll get the language correct so I don't read it to you wrong. I pointed out that within the letter, it stated that was sent to the respondent with the complaint, says you are hereby notified that you must send a sworn and notarized statement answer in duplicate to this office within 10 days from the date upon which the receipt was signed. I pointed that out. This individual repeatedly stated, this is a prestigious designation organization. I trusted them when they said that they would take care of it. I didn't hear anything otherwise until a couple months later when I received the consent order, which was just unfortunately because we had more complaints ahead of it, so it was a few months down the road. The respondent asked, in light of the fact that because the respondent relied on this complainant being who it was, that it would be resolved, that it would be, and that was the reason for it. And he asked that the Commission consider possibly a lesser penalty. I'm presenting that to you. I wanted to give you the language that was in the letter to let you know that it did state that, but in light of the fact of the what the complainant's position here, and the fact that they did send a letter, purportedly attempting to try to resolve it there. I guess they didn't understand the process. I just thought it was worth at least bringing it back for you to consider.
What did you say the language of the letter was?
The language in the letter that Mr. House sends out to all the complainants.
Okay, you don't have to go back through that.
Yeah, it's what would have been sent to this respondent along with a copy of the complaint.
Mr. Chairman,
Commissioner Alexander.
I move that we stay like we voted the last time. That's my motion, that we do not reconsider it.
Second.
We have a motion by Commissioner Alexander and seconded by Commissioner Bloom that we do not reconsider the action that we took last month, and that we maintain the penalty that was voted upon last month.
Mr. Chairman,
Yes.
I would like to abstain since I wasn't here for that vote last month.
Okay.
Emily, what was the penalty that we voted last month?
$1,500.
And attendance
And
at a
attendance
meeting?
at the meeting, I'm sorry.
Okay.
We have a motion and a second on the floor. Is there any discussion on the motion?
I ask a question,
Yes, you may.
Chairman. Ms. Crop, is the provider of that designation associated with the National Association of Realtors?
I don't believe so. I'm not positive. I don't know. I've heard of this designation before. It's not some small one, but I'm not positive. Do you?
The CCIM, it's CCIM, so it is affiliated with NAR.
Okay, well, then the reason I ask is it's a violation of the Code of Ethics to have been using that, whether she knew that it expired or he knew it was expired. So it's not like, that's a separate issue from the issue we're looking at, but knowledge has been given to her or him that they should not be doing that.
Well, and this person stated that they had been, pointed out that they had been licensed since 1985, and hadn't gotten in trouble before. It appears that in the history there was a matter that was closed with a $1,000 consent order for failure to supervise for errors and omissions, but this person said that they relied on the statements of the complainant that it would be taken care of. And like I said, I explained that the letter said that there must be a notification, and that also there was the underlying advertising which took place, and even though resolved was a matter for the commission, but in light of the kind of particular set of circumstances, that's why I brought it to you. So.
Any other questions or discussion on the motion? Hearing none, all in favor of the motion, say aye. Aye. Opposed, no. Motion carries 7 ayes and 1 abstention.
I'll start with the first matter on this month's report, which is two numbers. It's 2013009941 and 2013009942. The complainant was the joint owner of a home with complainant's girlfriend, and when the relationship ended, the court ordered the property sold at public auction in September 2011. Complainant contacted Respondent 1, broker. Respondent 2 is Respondent 1's principal broker, and asked Respondent 1 to purchase complainant's home at auction because Respondent 1 was an investor. Complainant then planned to repurchase the property. Complainant states that Respondent 1 told complainant that Respondent 1 knew an investor was willing to purchase the home at the court-ordered sale, and Respondent 1 stated the investor's fee would be $5,000, but the day before the public auction, Respondent 1 told complainant the investor would require a $10,000 fee. Complainant questions the amounts referenced on the HUD statement from the 2011 sale of the home to the investor. After the sale to the investor, complainant and the investor immediately entered into a purchase and sale agreement with complainant as the buyer, which provided that complainant would lease the property until closing. Complainant states that the rental payments were given to the investor through Respondent 1, and the rental payments were supposed to be used to cover the interest on the investor's mortgage. Complainant states that complainant was not aware that the investor had a variable interest rate loan, and the interest later increased. When the second closing occurred with complainant repurchasing the home, complainant again raised issues with the numbers on the HUD statement. After the closing, Respondent states that complainant states that complainant was given a much smaller amount than complainant was initially told, and complainant believes that this was due to the acts of several parties, included but not limited to Respondent 1 and the bank who had the investor's loan on the subject property. Respondent submitted a response through an attorney stating that complainant contacted Respondent 1 about buying a home, but Respondent's role in this transaction was not as an investor. Respondents state that Respondent 1 was asked to help complainant find an investor to purchase complainant's home that was to be sold at auction by court order, which was done, and later when complainant repurchased the home, Respondent 1 received a standard commission for that sale. And ultimately, an investor negotiated an agreement with complainant with the intent being that complainant would later buy back the house. Respondents state that Respondent 1 had no agreement to receive payment relating to the auction, and it is believed that the buyer and complainant had an agreement for complainant to pay the buyer to purchase the house at auction and pay fees associated with the buyer purchasing the house, with complainant later buying back the house from the buyer. After the buyer purchased the home at auction, a closing occurred in November 2011, and on the same day, the buyer and complainant entered into a purchase and sale agreement for the same property, with complainant leasing the property until closing. Respondent 1 was the transaction broker facilitator for this transaction, as confirmed by a signed confirmation of agency status form. Respondents state that complainant was going to live in the house until closing and make repairs, and then an appraisal would be performed to determine how much complainant could borrow to purchase the home. Respondents state that no representations were made regarding financing, who would finance the home, closing costs, or how much money complainant would receive at closing. Respondents state that complainant did not make all of the intended repairs, and there was a lower than anticipated appraisal value. At the closing of the sale of the home from the buyer to complainant, which occurred in May 2012, the buyer received a settlement which was reflected on the settlement statement, and the buyer paid complainant an amount agreed upon by those parties. Respondents state that if complainant is unhappy with the amount, that is an issue that did not involve respondents, and any issues as to what complainant believes should have been paid to complainant by the buyer between those parties and do not involve respondents. Both parties have attorneys who submitted numerous documents to assist in the outline of the events that transpired relating to this rather involved transaction. Based on a review of the documents and the information submitted, while it appears that there may be the potential for a court action involving multiple parties, including parties other than complainant and Respondent 1, it does not appear at this time that there was a violation of TREX laws and/or rules by respondents, and therefore the recommendation is to close.
Ms. Crop, could you tell us how that recommendation would differ from a recommendation to dismiss?
This was a very, very complicated transaction, and both attorneys submitted a lot of information. To me, at this time, it does not appear that there's a violation. It's possible that there could be something that could come up. There's not been litigation filed, which is reason that there is no litigation monitoring consent order recommended. If something came up during the course of litigation that there was something that had been done wrong, I didn't feel that dismissal was necessarily appropriate. It could possibly be reopened if later information was given. But at this point in time, after my review, there are reviews several times of the information. I did not see at this time that there was a violation.
Mr. Chairman, I move that we adopt council's recommendation.
Second.
I have a motion by Commissioner McMullen, and seconded by Commissioner Collins, that we take council's recommendation and close this file. And we have a question from Commissioner Grease.
Julie, so how many parties are in this deal? You got a complainant, a respondent and his broker or her broker, and an investor. Is that correct?
And then there was an auction real estate company that conducted the first sale. There appears to have never been any issue with how that auction was conducted, so I would not consider the people that performed the first auction a party at all. There's also issues that appear to be with the bank. There appear to be claims that the bank may have done something wrong. There also may have been issues with the people that prepared the settlement statement. There appeared to be vague claims that they may have done something incorrect.
So in the last paragraph, just before your recommendation, you say both parties have attorneys. Who are those parties?
The complainant and the respondents. The complainant submitted original response, later submitted an amended complaint that was drafted with the assistance of an attorney, and the respondent submitted both of their responses, the original complaint's response and the response to the amended complaint by an attorney. They both had attorneys that drafted and responded regarding this matter.
Do you suspect this is going to court?
I suspect that it will, but I don't think it will involve just these parties.
In previous cases where court action was possible, your recommendation was to monitor.
That was only when it had already been filed, when it was already in litigation. I don't know. I have no verification that there will be any. There may be. I don't know.
At some point in the future, if there is litigation and a court finds the respondent or respondents guilty, are we leaving the door open for them to come back, or does this shut this thing down?
I believe that if there was something uncovered that we didn't have a knowledge of now, something that came to light, that it would be a potential that we could either open this one back up and proceed or have a new complaint, because that's information that we didn't have access to at this time.
I have any other questions or comments? Before we vote, I'd just like to point out and let the record show that the auction company that was involved in this didn't do anything wrong, so.
Well, it didn't appear. Nobody said anything about them.
Yeah. Any other questions or comments?
Still must have been a Middle Tennessee.
If not, all in favor to council's recommendation to close, say aye. Aye. Opposed, no. Say no.
2013-011-511, 2013-013-911, 2013-015-201. These are three separate complaints opened against the same respondent, which is a principal broker. The first complaint, 2013-011-511, was opened based on information received from an anonymous individual who stated that respondent was operating a property management firm with an expired firm license, and that respondent was operating the firm office in a residential location. Respondent attached a photo which did not have a date stamp or clearly show the location where the picture was taken. A complaint was opened based on the information, and a copy sent to respondent. Respondent submitted no response to this complaint, which was sent to the firm address on file with the commission and signed for by an individual there. Soon thereafter, it was discovered that respondent's firm license was not actually expired but was showing up in the system as such because respondent renewed the firm license after the expiry date. The system attached an additional late fee due to the date on which the payment processed, thus inaccurately showing an expired firm license at first glance. The second complaint, 2013013-911, was originally opened as an agreed citation sent to respondent for failure to notify the commission of an address change within 10 days as required by statute. The same anonymous source from above furnished more dated pictures indicating that respondent's firm had moved to a new location and had not notified TREC of the firm address change. The agreed citation was returned by the Postal Service with the notation of the new address, same address provided by the anonymous source. The agreed citation was then sent to respondent at the purported new address, which was returned unclaimed. The third complaint, 2013015-201, is a consumer complaint against respondent. Complainant is a property owner and respondent was complainant's previous property manager. Complainant states that complainant attempted to cancel the property management agreement with respondent's firm after complainant did not receive rent money from respondent for 2 months, but respondent was unresponsive. Complainant has hired a new firm to handle the property management, but states that the respondent will not turn over rents collected, hand over keys, pay back deposits to tenants who moved out, or forward current tenant deposits to the new management company. Complainant provided documentation of some payments which were received by respondent from various tenants, which complainant says were not turned over to complainant. The complaint was sent to respondent's new address and returned unclaimed. Because respondent's last 2 complaints were returned unclaimed, legal counsel sent additional copies of these complaints to respondent via regular mail, U.S. mail, and requested an investigation. Legal counsel was contacted by an attorney who stated that he represented respondent and would attempt to answer the complaints. Respondent's attorney later sent an email to legal counsel for the commission and the investigator stating that the attorney did not receive the information requested by the investigator from respondent. The attorney stated that he did not have enough information from respondent to respond to the complaint. The attorney indicated that respondent wanted to get out of the property management business. The investigator visited the firm address on file with the commission and spoke with the man who lived there, who stated that respondent did not live there. The investigator then went to the address where the anonymous source stated that respondent was operating the firm and found a sign with the firm name and telephone number where no one answered. The investigator took photos of both locations. The investigator then spoke with respondent's attorney and provided a list of information requested in the investigation request. The investigator never received the requested information, but only the aforementioned email from respondent's attorney. The recommendation is a consent order for voluntary and permanent license surrender for failing to respond to a complaint filed with the commission in violation of Tennessee Code Annotated Sections 6213-312B14 and 6213-313A2, failing to timely notify the commission of a change of location of the office in violation of Tennessee Code Annotated Section 6213-309A3, and failing within a reasonable time to account for or remit money coming into the licensee's possession that belongs to others in violation of Tennessee Code Annotated Section 6213-312B5.
Ms. Crop, with the investigation that you've done on this, does it appear that this respondent is truly getting out of the business or just avoiding us?
I have not been able to contact this person. The investigator was unable to. The only information I received was from the attorney who apparently had spoken with this respondent and said that they wanted to get out of the business, indicated that the person might be willing to surrender, licensure without admitting fault. But in light of all of these, that's not a possibility here. But I don't know how many clients this person has.
Have you done web searches or anything to find out if there's anything online?
I couldn't find any, hardly. That's why I requested the investigation. I couldn't find much information about this person. And prior to this, prior to these 3 complaints, 2 of which were staff open and 1 was from a former client. We hadn't had any complaints. We haven't had any in the future. I don't know how large of a business this person is even doing. I just haven't. I exhausted all the means of trying to investigate it that were at my disposal, and I don't know.
Mr. Chairman, I'll move that we accept council's recommendation.
Second.
Have a motion by Commissioner Grease and seconded by Commissioner Franks that we take council's recommendation. Is there any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously.
Number 6, 2013-014711. Complainant was the buyer of a property and respondent, affiliate broker, represented the seller. Complainant states the property was listed as a triplex, but after purchase, complainant discovered that the property was not a legal triplex and had been rented that way illegally by the previous owner. Complainant also states that complainant requested a revision to the contract to address a leak in one of the showers, and respondent represented that the leak was fixed and the provision did not need to be in the contract. Complainant states that when complainant first used the shower, water was discovered in the basement, and upon relaying this information, complainant was told that the respondent seller were not responsible as the issue was not in the contract. Complainant further states that after purchase, other leaks were discovered, making none of the bathrooms functional, and respondent refused to address the issue. Complainant further states that at the final walkthrough, complainant discovered that a large tree had been cut down and there was a long electrical tube exposed. Complainant states that the complainant asked respondent if the home had had any water intrusions from the 2010 flood and was told no, and the disclosure was marked as such. Complainant states that the house floods, but respondent claimed ignorance regarding this issue. Complainant's respondent should have known of many of these issues, as respondent had managed the property on behalf of the seller. Complainant further states that the contract provided that the seller's items would be removed from the property prior to closing, but that on possession this was not done and it took weeks for the for sale sign to be removed. Respondent states that respondent did not manage the property and had no dealings with the property prior to listing. Complainant was represented by a licensee, and respondent states that there were actually two contracts with complainant, but complainant terminated the first contract when the seller did not agree to make all repairs requested by the complainant. Respondent states that respondent was later contacted and informed that complainant was interested in submitting a new offer with new terms, and a new contract was executed. Respondent states that the property had been rented for several years as 3 separate units and was referred to as a triplex by the owner, and complainant had representation and time to evaluate the property, but respondent never made representations regarding permitted use under current zoning as a triplex. Respondent further states that complainant became aware of the shower leak when complainant had an inspection done as part of the first failed contract, and the seller engaged someone to repair the leak. Respondent states that the first contract was terminated by complainant due to refusal by the seller to make a number of repairs, and when the second contract was entered, respondent informed complainant's broker that based on the information respondent had, the shower had been repaired. Respondent states that complainant had an inspection period, but no inspections were made until the final walkthrough. Respondent states the respondent was not aware of any long-standing water issues, and complainant had a contingency period for inspection. Respondent states that at the walkthrough, everyone was surprised that the tree had been cut down, which involved an issue with the bank and the insurance company, and respondent states that the buyer and buyer's agent said that they would address the issue, and the parties proceeded to closing. Respondent states that respondent was not aware of any previous flooding and was not given any information regarding previous flooding of the property. Respondent states that the seller hired a house cleaner and handyman to address cleaning and removal of items, and respondent was told that the cleanup and debris removal was complete. Based on the information provided, there does not appear to be a violation by respondent, and therefore the recommendation is to dismiss.
Julie, does all this appear to be contractual dispute to you?
Yes, and also a lot of the
adverse facts.
A
and
lot
disclosure.
of the things, knowledge of, there appeared to be no proof that this respondent had knowledge of it, that they were relying on the information given by the seller, and it didn't appear that there was proof that this person, knew of some of the issues that the complainant believes that they knew of.
Well, there's one issue. There were 3 people living in there, and why would the listing agent not have checked to see if 3 people could live there when he was selling the property?
I don't know the answer.
Complex.
I don't know the answer to that. Apparently, it had been constructed as 3 units, and the owner had been utilizing it, and I guess that this person did not.
But by that person's actions, they were purporting that somebody could buy that and have 3 tenants live there.
And this person says that was the information given to them by the owner.
But we should hold a licensee to a higher standard than my owner told me this.
If you're in a county like I'm in, you have no county planning commission or no zoning, and if it's outside of an incorporated town, you could have it.
Well, then there's no
But
violation.
evidently, that wasn't the case here.
I don't
They didn't
know.
make a walkthrough. The realtor did not make a. The licensee didn't walk through the house.
I can't see if the same agent wrote two contracts, and he tells this client that there's no need to put it in a second contract because it'd been fixed. Seemed to me like he had knowledge of it.
The person said that the seller had said it had been fixed, and so that this respondent said the seller tells me it's been fixed, and therefore the issue'd been resolved. So
I'm kind of like Wendell on that one. I think that agent still had a responsibility to that buyer to protect them because they knew that there had been a previous leak, that it should have been mentioned in that second contract.
no, are you? Because this respondent here was representing the seller, was not representing the complainant. The complainant had his own representation, his own licensee that had been representing him in both contracts as well.
So there wasn't a complaint filed against the agent who refused to write that up in the second offer or second contract?
The complaint was against the seller's agent, who apparently told the buyer or the complainant's agent, this was taken care of, and it was just not put into the second contract based on that email.
The complaint against the wrong person.
I wanted to be clear, and I know it's sometimes hard when it's anonymous. This was not the licensee representing the complainant. This was the licensee who was representing the other party to the transaction, and there was a licensee representing the complainant. Does that make sense? I'm sorry, it's very hard to do anonymously sometimes.
Was there a buyer representation in the folder?
I'm not sure, because
It doesn't really
the
matter.
respondent was the listing agent, so I'm not sure if I would have been provided with that document because that wasn't the agent list, I'm sorry, was not the buyer's representative.
Are you comfortable the buyer was represented?
Yes, there was I believe there was a confirmation of agency signed that had both people on there, or
Point, Gary.
I'm sorry, I looked at
Somebody
some-
should have told him. But if he's represented by a buyer's agent, then
Got that, but I think the listing agent has some responsibility. What would we do if we had a listing agent who said, well, they're using it to sell McDonald's, so I guess it's zone commercial, and we find out it's zone residential?
I wish I could make a motion. I make one.
I'll make one. I make the motion to accept council's recommendation.
I was going to make.
Already made that motion,
Yeah,
and it died for lack of second.
I was going to make a motion that we let Commissioner Bloom take his
I was too. That was where I was going
take
with
his
that.
file to Memphis with him and study it from an angle of.
I'll second your motion, Mr. Chair, or would you rather do that in reverse?
Well, I mean, they didn't investigate it. I don't know if, this respondent admits I took, the seller, that it was being used this way. I don't know that looking at it, there would be a document to see that any further. I mean, they say the seller was using it as that, it was walled off as that, and that's what I was told it was, and so that's what I listed it as. So if you consider that a violation, that's something we can handle. Now, I don't think that there would be
Okay,
anything in
septic
here.
tanks. If somebody could be using a house for 3-bedroom and it's approved for a septic tank of 2, you cannot sell that for a 3-bedroom house.
Where you from?
No. In the state of
And that's our
Tennessee.
responsibility as agents to determine that.
Wendell told us they didn't have any septic tanks in his county.
That's right, in a lot of places. That is true.
Ms. Cross, statute says, I'm looking at 6213-312B1, that it's a violation to make any substantial and willful misrepresentation. So it would be willful if the licensee knew that it couldn't legally be used as a triplex, but if we don't have any proof that the licensee knew that, it doesn't seem like we could travel under B1. Is there any other provision that could possibly apply in that situation?
Other than just the only thing that comes to my mind is under the 400s, just under the, if you found it appropriate, the duty owed to all parties, there's a duty to diligently exercise reasonable skill and care in providing services to all parties to the transaction. That's the only thing that comes to my mind. But under that, it says disclose to each party to the transaction any adverse facts which the licensee has actual notice or knowledge. And in this case, there's no proof that there was actual notice or knowledge, but like I said, the failure to diligently exercise reasonable skill and care is the only thing that comes to my mind off the top of my head.
Well, the other thing that bothers me too is that listing agent knew there was a water leak. And then just said, well, the seller said it's fixed, so it's okay and we don't need that in the other contract. Would seem to me that agent should have pursued that and asked for some kind of proof that it had been repaired.
Before they gave that advice.
Yeah, before dismissing that.
You can't prove he's in it, though.
We got to make some kind of decision.
Didn't put it in the contract,
you had
told
a
him it wasn't
motion and a
necessary to put in the
second that it
contract.
be
He admitted that.
We did, but it's,
Call for the
That
question
he
on
said
that
he
motion.
didn't,
well, I mean, it
he told him it wasn't
didn't get
necessary.
made.
Had a first.
No, we hadn't had one. I just,
Grover made a motion, but nobody seconded it.
I didn't make it. I can't make one. I just
I
said
make
if
a
could.
motion that Commissioner Bloom take this file and review it for us.
Commissioner Bloom, is that satisfactory to you?
I'll do that, sir.
I'll second that motion.
We have a motion and a second that Commissioner Bloom take this file and review it and bring us a report back next month. Any discussion on the motion?
Yes, sir, I think that's a delaying tactic, and I think we've got the proof here, and I hate to put a relatively new commissioner on a job like that. It's ridiculous.
Well, y'all didn't hesitate to do it to me.
I didn't want to do it to you either.
I have a
Or John either.
if this helps, I have a copy of an advertisement in here which states how it is zoned in here. It states that it's commercial/office low-rise building. It says zoned OR20/OV-UZO. The advertisement does not say it's a triplex in here. That's what it says with regard to how the property is.
So there's different things that are allowed in that zoning. And it would be, if you were looking at that ad, you would need to look up to see what that zoning allowed.
So the summary says that complainant states the property was listed as a triplex, but you're saying that the advertisement did not list it as a triplex.
The specific wording of the complaint is that it was false representation as a triplex, that it was divided into 3 units when it was that it was divided into 3 units, and then after purchasing it, the complainant found out it could really only be utilized through the zoning commission. It could really only be 2.
But it wasn't listed in the advertisement as a triplex. They just listed that the zoning is whatever you just read to us.
Right, and the complainant says that the respondent repeatedly referred to the property as a triplex, both verbally and in written emails.
Any other discussion on the motion, which is to give this file to Commissioner Bloom and bring us a report next month?
I'm just trying to get a sense of what Commissioner Bloom could get out of that file.
That's what I'm just wondering, but I mean, it's up to you all, of course. It's just, I'm trying, that advertisement was the only indication, the only advertisement that was included.
Are there emails in that file that say it's a triplex?
There are emails.
Have to go back to the zoning.
Wendell?
And what that,
Wendell, move to the front.
and what that zoning says, you might could have had a triplex in that zone. And you talk about the septic tank, if if it's in a place that's zoned, it may be on city sewer. I see more misrepresentation, what one agent said to the other than I do of the zoning or the other, or the triplex part. You take a lot of these old houses that have been converted to triplexes, and duplexes, and
It refers to it in passing. It says, anyway, hopefully it will be permanently fixed with the repairs you are planning on the triplex is how it's utilized in the email.
So far, I don't have any reason to believe it's a residential triplex, do I? Those zoning codes, it could well be a commercial or office complex. Don't know.
A commercial on the advertisement.
I know it is.
It says residential on the advertisement.
It says
Question.
commercial on the.
Question has been called on the motion, which is to let Commissioner Bloom review this file and bring us a report next month. Question has been called. All in favor of the motion, say aye.
Aye.
Opposed, say no.
No.
Motion failed.
I voted no also.
Commissioner Grease, it does say commercial / office, low-rise building is what it says on this
Wendell did.
advertisement.
No, Grover did, and Wendell seconded.
The motion failed.
Now. So, we're back to the drawing board. What are we gonna do with it?
Roll call.
Wasn't there a motion to accept recommendation of council by committee?
Never did get a second.
Oh,
It was
I
No,
thought
I
you
made
made
that
the
motion.
motion.
I made it and seconded it too.
We have a motion, Commissioner Alexander made that motion first, and it just, nobody ever seconded,
and it
and Grover Collins seconded your motion.
Mr. Chairman, I have a motion then.
Okay.
I move that we adopt council's recommendation.
Second.
We got a motion by Commissioner McMullen to accept council's recommendation, and second by Commissioner Collins. Any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no.
No.
Call the roll, Mrs. Maxwell.
This is on the motion of Commissioner McMullen to adopt the recommendation of council. Flitcroft absent. Franks?
Yes.
Alexander?
No.
McMullen?
Yes.
Bloom?
No.
Collins?
Yes.
Grease?
Yes.
DeChara?
No.
Stevenson?
No.
It's a tie.
4-4.
4-4.
Fails.
It fails.
I just was going to see if everyone felt good about their
I'm
vote.
surprised that Bear took a chance on that vote like that.
Yeah, eat chicken.
No.
Now, I'm gonna come back and make a motion again that it be given to Commissioner Bloom to review.
It's gotta be a motion.
And I'll second that again.
Okay,
We already voted on that.
I know, but we don't know where we were. We have Commissioner Alexander makes a motion to give it to Commissioner Bloom to review, bring us a report next month, and did you second it?
I did.
And Commissioner DeShara seconds that motion. Call the roll, Ms. Maxwell.
Oh, is this according to Robert's rules of order?
We're making it Robert's. Robert said that.
This is a motion by Commissioner Alexander to give the file to Commissioner Bloom to review and report on in February of 2014.
He has agreed to that.
And he's agreed to it.
And he's agreed to that, yes. Flitcroft absent. I'll start at the bottom. That'll be better, won't it?
Alphabet.
Stevenson.
Yes.
DeChara.
Yes.
Grease.
Yes.
Collins.
No, because Robert's Rules of Order have been adopted and we're out of order.
Motion to reconsider can only be made by the prevailing party. I'll keep calling the roll.
Keep calling the roll.
We didn't have a prevailing.
Bloom.
I'm going to abstain.
I believe I would.
McMullen.
No.
Alexander.
Yes.
Franks.
No.
So there's 4 yes, 3 no, and 1 abstention. Motion carries. If, yes.
Okay.
Good luck with that.
We did not do a count, Kelly, on that first motion, and that's probably why it came back around.
No.
No, in the first.
Commissioner Grease, the motion to reconsider. Is that what we did?
You just trampled on the rules, Robert.
That's right.
You're the chair. You live with them.
I am.
It was the same vote, except that he abstained.
I believe I called for a roll call and it never happened. I got ignored on the first motion.
It's chair's fault again.
That was my fault again. I apologize.
Now what are you gonna do?
We voted on the same motion. and we
I
have a
voted the
record of it.
same way both times.
I did too.
So if everybody voted the same way every time, then that answers your question.
I changed.
You
I
changed.
tried to break this up so we could move forward. So I voted yes the second time, Mr. Bloom.
Let's adjourn and go home. Move on, so do something.
I think we have.
Yeah, that one's finished.
Yeah, we finished with this one.
Till next month.
Till next month. And
Okay.
we'll-
The next three are 2013-015-291, 2013-017-771, 2013-022-141. These are three separate complaints opened against the same respondent, an unlicensed individual. In the first complaint, 2013-015-291, complainant is a property owner who states that complainant hired respondent, unlicensed individual, to manage complainant's rental property. Complainant states that complainant does not remember signing any documents and did not receive copies, and respondent rented the property to a tenant but failed to provide any documentation of expenses or where the money was being spent, but complainant received different amounts each month from respondent with no explanation. Complainant hired a new management company but states that respondent refused to send a copy of the tenant lease agreement or the security deposit to the new company. Complainant attached a copy of the rental agreement with the tenant, which was between respondent's company and the tenant, signed by the tenant but not respondent, which provided for rental payments to go to respondent's company and a security deposit would be paid to respondent's company. Respondent submitted a reply stating that respondent's company did not have a rental agreement to manage complainant's property. Respondent states that complainant hired a company sharing office space with respondent to renovate complainant's property. Respondent states that both complainant and the tenant separately expressed interest in respondent's company managing the property, but respondent told both individuals that respondent's company only handled HOA management and was not licensed for rental properties. Respondent states that respondent advised the tenant of complainant's property, the two connected, and respondent provided a sample rental agreement for complainant to use. Complainant provided email chains between complainant and respondent referencing respondent finding a tenant, depositing complainant's rent funds, and providing a spreadsheet of income and expenses. Based on this information, it appears that respondent was engaged in unlicensed activity. In the second complaint, 2013-17771, complainant is a property owner who states the complainant has been attempting for 6 months to obtain rent checks, invoices, repair receipts, and an accurate budget sheet from respondent, who has disregarded complainant's request. Complainant states that complainant discovered that respondent's company is not licensed to manage single-family homes. Complainant attached a rental property management property owner agreement between complainant and respondent's company, signed by complainant but not respondent, which in part provided that respondent's company would show the property to prospective tenants, process rental applications, collect rents, maintain the property, advertise, market the property, and sign, renew, cancel leases in exchange for 10% management fee. Complainant also provided a copy of a fully executed rental agreement with the tenant between respondent's company and the tenant, which provided for rental payments to go to respondent's company and that a security deposit would be paid to respondent's company. Respondent submitted a response stating that respondent's company has no rental property agreements under contract to date, is not holding any deposit, and does not handle complainant's rental property and is not collecting rent on complainant's behalf. The documentation indicates that respondent was engaged in unlicensed activity. The third complaint, 2013-022-141, complainant is a property owner who states that complainant hired respondent's company to handle rental of complainant's home and immediately began experiencing problems with the management. Complainant states that rent money was not timely deposited to complainant and respondent refused to provide complainant a copy of the property management agreement or lease agreement with the tenants. Complainant states that respondent finally agreed to cancel the management agreement for a fee. Complainant states that respondent failed to provide paperwork relating to the property management or to turn over escrow money or the tenant security deposit, and complainant got a judgment for the money, but complainant states that respondent is unlicensed and had complainant sign an agreement agreement with another unlicensed company under the guise of a second unlicensed company operated by respondent. Complainant attached a fully executed rental property management property owner agreement between complainant and respondent's second unlicensed company, which in part provided that respondent's company would collect rents, provide accountings to complainant, maintain the property, advertise, market the property, and sign, renew, cancel leases in exchange for a management fee. Complainant also provided a copy of a fully executed rental agreement, which provided for rental payments to go to respondent's company and that a security deposit would be paid to respondent's company. Respondent submitted a reply stating that respondent has ended all rental business and there is never any intent to conduct either unlicensed business in a fraudulent manner. Respondent states that respondent is not managing any properties under any name and is not holding any deposits. Further, respondent states that complainant has been paid in full. Respondent does not handle complainant's rental property and respondent is not collecting rent on complainant's behalf. The documentation indicates that respondent was engaged in unlicensed activity. The recommendation is a consent order for $3,000 for unlicensed activity in violation of Tennessee Code annotated sections 6213-103 and 6213-301. Said order to also include an order to cease and desist all unlicensed activity.
Make a motion, we accept council's recommendation.
Second.
Motion by Commissioner DeShar to accept council's recommendation on this complaint, and second by Commissioner Franks. Any discussion?
Just, Julie, what, do we have any teeth? I mean, we can pass this. How do we collect it?
It would go forward to a formal hearing. Then either the person will appear or they won't. There'll be a final order, and then I believe collection attempts are made through the Attorney General's office. Am I not? Oh, no, I'm sorry.
Under 10,000 will ultimately give them to a collection agency hired by the state for collection.
Robin, would you mind stepping up there where I can hear you?
Would not mind. Right now, the standard is for collections of under $10,000, it goes to a collection agency that has not yet been retained by the state, who would then pursue those collections. Collections over $10,000 would be referred to the AG's office, who would then handle it in the way they see fit.
Have a motion and a second. Any other discussion or questions? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously.
2013015-431. Complainant states the complainant had a lake home that complainant attempted to sell, and potential buyers who were under contract to purchase the home did not complete the sale due to the home inspection and other issues with the home. Complainant states the complainant removed the property from the market, updated the interior, and addressed the items within the home inspection. Later, complainant again listed the home for sale and reviewed the inspection report with complainant's new listing agent. Complainant states the respondent, affiliate broker, and respondent's potential buyers requested a viewing, and complainant and respondent spoke prior to the potential buyer's arrival. Complainant states that respondent told complainant that respondent knew the neighbors. Complainant states that respondent's potential buyers made an offer and the parties attempted to negotiate a contract. Complainant states that in these negotiations, respondent told complainant's agents that the property was not worth the asking price because respondent had information regarding the home's previous list price and the previous contract fell through due to home inspection. Complainant states that complainant discussed this with complainant's agent and told the agent about respondent's previous comment about knowing the neighbors.
Motion to dismiss.
Second the motion.
We have a motion to dismiss by Commissioner Collins and seconded by Commissioner McMullen. This is Commissioner Grease.
I understand Commissioner Collins' motion, but frankly, I haven't read this, so I need to hear it before I vote for it.
Okay.
Continue on, Ms. Crop.
Respondent states that respondent.
A motion on the floor.
I know.
You got a
Okay.
vote.
We got a motion and a second on the floor. All in favor say aye.
Aye.
Opposed, no. No. Continue on, Ms. Crop.
Respondent states that respondent did say that respondent knew the neighbors when meeting with complainant. Respondent states that respondent's potential buyers discussed the property and issues including but not limited to a shared well and a shared driveway. After this meeting, respondent states that respondent spoke with the neighbor about the shared well and other issues, and the neighbor stated that a previous contract fell through due to home inspection. After this, respondent states that respondent's potential buyers still made an offer even after learning this information, and after multiple counteroffers between the parties, an agreed upon price could not be reached to result in a contract on the house. Respondent further states that complainant's property disclosure was inadequate and explaining what had occurred with the home. Respondent states that respondent worked for respondent's client's best interest and researched the issues regarding the home and ultimately assisted the clients with finding a home that better met the client's criteria. Respondent further states that respondent's potential buyers did not want to pay more than the property's original list price. Based on the information within the file, there does not appear to be a violation by respondent, and the recommendation is to dismiss.
Any questions of Ms. Crop?
I make a motion to dismiss.
I'll second.
Have a motion by Commissioner Franks to dismiss and seconded by Ms. Franks. You made the motion. Did you second it?
No, John did.
John did. John, I'm sorry. Commissioner Grease seconded that motion to dismiss. Any discussion on the motion? All in favor say aye. Aye. Opposed, no. Motion carries and it's been dismissed. After this next complaint, we'll take a short 10-minute break.
11-2013-01-5501. Complainant is a licensee who states that respondent, an unlicensed individual, is engaged in unlicensed real estate activity. Complainant includes notes from an unnamed individual who states that respondent was contacted and stated that respondent did not have a license, but that respondent showed homes and charged between $5,000 and $10,000. According to the unnamed person's notes, respondent stated that respondent advertised the homes but did not write the contracts. An attorney wrote the contracts and closed the transactions. And respondent stated that respondent was told by the brokers in the area as well as an attorney that respondent was doing nothing wrong. A copy of a for sale by owner sign is attached, which contained respondent's telephone number. The notes indicate that respondent stated that respondent only opens the doors and sends information to a lawyer who drafts documents, and respondent is paid to unlock the door depending upon the price of the home and how many times respondent has to show the home before it closes. The unknown individual's notes indicate that complainant and respondent had a disagreement regarding homes which were built by respondent, which were formerly sold by complainant. Complainant submitted additional information stating that respondent is facilitating transactions by putting out for sale by owner signs with respondent's contact information when respondent is not the homeowner. Complainant states that respondent facilitates sales by arranging with owners in advance for an agreed upon commission for opening doors, giving potential buyers information on the property, and negotiating a contract. Respondent states that due to health issues, respondent is removing respondent's phone number from the one home that respondent was helping the owners with. Respondent states that respondent only helped owners with homes that respondent built by advertising their home for sale by owner, by letting people look at the homes, and by letting people in the homes to do work and repairs. Respondent states that the homeowners facilitated all sales and negotiations through their own means. Respondent states that with regard to two homes, complainant would have listed the homes if complainant had not got into conflicts with the owners who no longer wanted to work with complainant. Respondent states that respondent does not solicit for sale by owner homes, but only helps after homeowners contact respondent in order to help the owners get the most out of their investment. Respondent states that if respondent's health improves, respondent will consider licensure. Legal counsel contacted respondent by telephone, who confirmed that respondent did accept money for performing the services referenced in the response. Specifically, respondent stated the respondent received $5,000 from a owner who had moved out of state and needed someone local to advertise on the sign, show the house, walk through the home to ensure it was in good condition, etc. Respondent states that respondent has ceased these activities, and legal counsel could find no information indicating that the activities are ongoing. The recommendation is a consent order for $500 for unlicensed activity in violation of Tennessee Code Annotated Sections 6213-103 and 6213-301. Said order ought to also include an order to cease and desist all unlicensed activity.
Motion to accept the recommendation.
Commissioner McMullen makes a motion to accept council's recommendation and seconded by Commissioner Collins. Any discussion?
Is there any interest in raising that amount of money? That's $500 and the person just snubs his nose at the real estate commission.
What can we find on that violation, Julie?
I believe the maximum's $1,000, and the reason why I didn't recommend the maximum was just because despite I contacted the complainant who did not have a lot of hard information. I had no documents to go by, and she gave me the name of one of the homeowners that had worked with this person, but stated that that person would be uncooperative to the efforts. And I found nothing showing that this person was advertising anything on there or had kept any money that didn't belong to them. I don't believe there's any contracts out there that would be showing what this person's doing. And just based on the fact that I don't believe that this is something that is nearly as widespread as one of the ones we had considered a few complaints back. So just based on the facts and the information that I was able, and I think will only be able to be obtained on this.
The comments or questions? Hearing none. Anybody? All in favor to take council's recommendation, say aye.
Aye.
Opposed, no. Motion carries. Let's take a short 10-minute break. Session. Ms. Crop, continue on with number 12.
Okay. 2013015591. Complainant was a potential buyer who contacted respondent broker for assistance with finding a home. Complainant states that complainant sold complainant's home and was on a strict budget due to a spouse moving to another country. Complainant states that respondent told complainant to contact a lender to discuss what type of mortgage complainant could obtain. Complainant states that complainant contacted the lender respondent referenced and received a pre-approval letter. Complainant states that a home was listed for slightly more than the amount contained within the pre-approval letter, and respondent contacted the lender to see if complainant could be pre-approved for the larger amount, which was done. Complainant states that the home had multiple offers, and complainant gave complainant's best offer, but later increased the offer due to respondent stating that it would not affect the monthly mortgage amounts by much, and complainant receiving another higher pre-approval letter. Complainant states that complainant made the offer, which was ultimately accepted, and complainant was asked by the lender to return additional mortgage documents. Then complainant states that respondent told complainant that complainant would have to get the utilities connected and the home de-winterized. Complainant states that the home had numerous plumbing leaks. Complainant states that respondent notified the listing agent of the leaks, and the seller eventually agreed to carry out the minimum repairs if complainant agreed to the earnest money becoming non-refundable, which complainant did not like, but complainant ultimately signed the addendum with these provisions and an extension on the closing date. Later, complainant states that respondent told complainant that financing was not possible and the seller was not willing to extend the contract further. Ultimately, the sale fell through, and complainant believes that this was due to the actions of respondent. Respondent submitted a response stating that respondent had no knowledge of complainant's available funds to purchase a home, but respondent did suggest that complainant first contact a lender concerning complainant's ability to secure a loan. Respondent states that respondent provided the contact information for a mortgage company, but states that complainant was free to use whatever lender complainant wanted. Respondent states that the pre-approval letter was contingent upon the lender getting sufficient documentation to support the information given at the time of application. Respondent states that the home complainant made an offer on was a foreclosure property which had multiple offers. Respondent states that as the home was a foreclosure, complainant was responsible for turning on utilities and de-winterizing the home. After inspection, respondent states the complainant was still interested in the home and the lender ordered the appraisal. Respondent states that the negotiations began regarding the seller paying for repairs, and complainant executed an extension and addendum acknowledging the seller's payment of certain repairs and the non-refundable earnest money. Respondent states that respondent was not aware of problems regarding the income claimed on complainant's application, and once respondent was informed of the issues, respondent suggested trying another lender. Respondent states that the second lender also had issues with complainant's income documentation. Respondent states that respondent worked diligently to help complainant find a home. Based on the information within the file, it does not appear that there was a violation of Trex laws and/or rules by respondent, and therefore the recommendation is to dismiss.
Move to accept recommendation.
Have a motion made by Commissioner Bloom and seconded by Commissioner Grease to take council's recommendation to dismiss. Any discussion on the motion? All in favor say aye. Aye. Opposed, no. Motion carries unanimously.
13 and 14, 2013-015941, 2013-015942. Complainants are tenants who had a lease agreement with Respondent 2, firm. Respondent 1 is the principal broker. At the end of their lease, complainants stayed and rented month to month. Complainants state that in mid-February 2013, complainants noticed the trash was not being picked up and the trash collector stated the bill was not being paid. Complainants called Respondent 2 firm and were told that the matter would be resolved. Complainants state that in March 2013, complainants received a letter from a utility company stating that the services were going to be terminated at the end of the month. Around the same time, complainants state that a letter was received from Respondent 2 stating that respondents were no longer managing the property and that beginning on April 1, 2013, payments should be made to the new owner because the building had been sold in a tax sale. Complainants contacted the county and received a letter at the end of March 2013 stating the property was purchased by the county for non-payment of taxes, then offered for sale, which was approved in mid-March 2013, and closing should be occurring within 20 to 30 days, at which time the tenants would be contacted by the new owner. The letter also stated that no management company had been authorized to collect rent for the months of January, February, February and March 2013. Complainants state that when they contacted Respondent 2 firm, individuals there assured complainants that their money would be refunded, but it has not happened. Respondent 1 submitted a response on behalf of Respondent stating that respondents were retained in 2007 by the property owners to perform management services. Respondent states that at no time were respondents notified of the pending tax sale by either the property owner or the county. Respondent 1 states that respondents did learn of a pending auction of the property but saw on the tax assessor's website that the property was still in the name of their client. Respondent 1 states that Respondent 1 spoke with an individual from the county who indicated that the county's policy upon taking ownership was to cease utilities and waste services and force tenants to move. Respondent 1 states that Respondent 1 assumed that respondents would be notified upon change of ownership but received nothing in writing from the county. Respondent 1 states that respondents continue to monitor the situation on the assessor's website and respondents' continued operation of services and collection of rents. Respondents attended the auction in mid-February 2013, and at that auction, respondent states that Respondent 1 was told that respondents could not continue to collect rents but were given nothing in writing. When the property was sold, respondents state the decision was made to cease involvement, but respondents were contacted by the new owner who asked for assistance in keeping the property occupied during the transition and closing month. Respondent 1 states that all tenants were told that respondents were not certain of respondents' obligation to return rents collected, as respondents had not known of the change of ownership until mid-February, and there was no way to get the money back from the original owner, and there was a balance owed to respondents for the management and care of the property, as well as expenses incurred in the interim time. Respondent 1 states that respondents attempted to keep track of the transaction on a weekly basis, but also thought they would receive something in writing from the county. Respondents state that they believe their continued care of the property served the interest of the tenants, and the tenants received benefits as well. Based on the information within the file, there does not appear to be a violation by respondents, and the recommendation is therefore to dismiss.
Motion to approve council's recommendation.
Second.
Motion by Commissioner DeShara, accept council's recommendation. It's been seconded by Commissioner Bloom. Any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously. Number 15.
2013-016061. Complainants were the sellers of a property and Respondent, affiliate broker, represented the buyers. Complainants state that Respondent allowed the buyers to take possession of the property prior to complainants closing and receiving the sale proceeds. Complainants state that the buyers' walkthrough was prior to the buyers' closing time, which is to be between 11 a.m. and noon. Complainants were asked for complainants were asked for permission for the buyers to park a U-Haul truck on the property prior to closing. Complainants state that complainants did not agree to allow the truck to be parked on the property and were assured by the respondent that the buyers made other arrangements. Complainants state that at the complainant's closing, complainants were informed that the buyers' closing on their own home in another state would not take place until later in the day, and complainants would not receive the money wire until the next morning. Complainants state that on the closing date, 3 U-Haul trucks were parked on the property, and according to neighbors, people were in and out of the house throughout the day of the closing. Complainants state that at complainant's closing, the keys to the home were turned over to complainant's agent, and therefore the keys or access to the home must have been given to the buyers by respondent. Complainants state that there were items in the home prior to complainants receiving the funds. Respondent submitted a response through an attorney stating that Respondent did not allow access to the property prior to closing. Respondent states that Respondent met the buyers for the walkthrough prior to closing, and Respondent took the key from the lockbox with Respondent. At the time, Respondent states the buyers asked if they could leave their U-Haul truck at the property, and after checking with complainant's agents, Respondent told the buyers that complainants would not allow it, and it was Respondent's understanding that the truck would not be parked at the property. Respondent states that the buyers completed their closing, complainants completed their closing, and Respondent was informed by the title agent that the sale had funded that afternoon, that the buyers could move in, but complainants had decided they wanted the funds to be wired in lieu of a check, and due to the timing, the wire transfer would not be completed until the following morning. That afternoon, Respondent states that complainant's agent indicated that complainants were upset that the buyers had been moving in all day, but Respondent states that this was impossible because the Respondent had taken the key from the lockbox and complainant's agent had the other keys and remotes. Further, Respondent states that the buyers denied moving anything into the home on the day of closing, but there were 2 U-Haul trucks parked on the property, which the buyers admitted was done against Respondent's instructions. Respondent states that at no time did Respondent give the buyers keys or allow them access, and Respondent specifically advised the buyers not to leave the truck in the driveway of the home. It does not appear that there was a violation of Trex laws and/or rules by Respondent, and therefore the recommendation is to dismiss.
Just out of curiosity, why or what motivated this individual to file this complaint?
I don't know that. The sale closed. I'm assuming they were angry at the set of circumstances. I didn't look at the timing. Sometimes people file complaints right after it happened because they're upset at how it turned out. I don't know. I don't know the motivation.
Seems so trivial.
sometimes agents just rub people the wrong way, if you know what I mean.
I fully understand, Commissioner Reese.
Motion to approve council's recommendation.
Second.
A motion by Commissioner DeShara to accept council's recommendation and dismiss, and seconded by Commissioner Franks. Any discussion or questions of Julie? Hearing none, all in favor say aye. Opposed, no. Motion carries unanimously. 16 and 17 is next.
201301621, 20130162122. Complainant was the potential purchaser of a short sale property who was represented by Respondent 2, affiliate broker. Respondent 1, affiliate broker, was the listing agent for the subject property. Complainant made an offer which was below the asking price, which was contingent upon 100% VA financing and a satisfactory home inspection. Complainant believes that it was wrongful of respondents to consult an attorney to assist with negotiating the price of the home, although it appears that complainant signed an agreement acknowledging that respondents would contact the negotiator. Ultimately, the sale did not go through, and complainant wants complainant's earnest money back. Complainant also believes that the reason the sale fell through was a scheme on the part of respondents. Respondents each submitted responses to the complaint. Respondent 1, the listing agent, states that the property was listed as a short sale pending third-party approval with 2 lenders involved. Respondents state that once complainant and the seller agreed on a sales price, the price was still subject to lender approval, and therefore the materials were to be submitted to a third-party negotiator to work out the short sale with the 2 lenders. Respondents state that it was disclosed in writing and signed by both agents, the seller and complainant, that the 1% fee to the short sale negotiator would come from the contract amount at closing. Respondents state that the banks countered with a higher offer, and complainant would not agree to increase the purchase price. Once the earnest money disbursement and release form was signed, complainant state that the earnest money check was sent to Respondent 2, who sent the earnest money check to Respondent. Respondent 1 states that Respondents 1 and 2 had never worked together before and did not know each other until this transaction, did not have any interest in the property, and have never tried to buy the property in any way. Respondents state that the property has not sold, no commission has been earned by either respondent, and neither respondent has paid money to anyone or for any reason regarding the property. Respondent 2 states that complainant contacted Respondent 2 and stated that complainant was unhappy because respondent should have known what the purchase price of the home was. Based on the information within the file, there does not appear to be a violation by respondents, and therefore the recommendation is to dismiss.
Move to accept council's recommendation to dismiss.
Second.
Commissioner Bloom makes a motion to accept council's recommendation and dismiss, seconded by Commissioner DeShara. Any discussion? All in favor say aye. Opposed, no. Motion carries. Number 18 is next.
201301641. Complainant, the owner of a firm, released respondent broker as principal broker of complainant's firm, and complainant reinstated complainant as principal broker of the firm. Complainant states that respondent became angry, withdrew listings from the MLS, and contacted the sellers, instructing them to withdraw their listings from the firm and relist with the respondent at respondent's new firm. Complainant also alleges that respondent removed a lockbox from someone's home, and when the 2 parties met to return the key, it appears that complainant and respondent got into an altercation. Complainant states that on the day following the release of respondent, the firm received multiple contacts from sellers who stated that respondent informed them that respondent had been fired. According to complainant, some sellers entered into a new listing agreement with respondent or respondent's new firm, and some sellers have not entered into a new listing agreement with anyone. Complainant attached documentation which included multiple written requests from sellers asking that their listings be withdrawn, as the sellers understood that respondent had been fired and sellers no longer wished to be represented by complainant or complainant's company. Complainant also attached copies of a sign that does not include the entire firm name, as well as what appears to be a postcard which does not include the entire firm name or firm telephone number. Respondent submitted a response describing what appears to be a personal disagreement between complainant and respondent. Respondent states that complainant was the owner of the firm and respondent was the principal broker. Respondent states that respondent was asked to sign a Trek 1 form releasing respondent as principal broker of the firm, and respondent was told to get respondent's things off of complainant's properties and to remove all of respondent's belongings from the office, and the 2 parties got into an altercation. Respondent then states that respondent removed yard signs, brochure boxes, and key boxes off the listings that respondent had listed as principal broker. Respondent states that respondent then withdrew the listings from MLS because respondent had not yet signed the Trek 1 form removing respondent as principal broker. Respondent states that respondent informed the owners why she was removing the signs and lock boxes at the instruction of complainant, and many clients asked where complainant would be going and how they could move their listings to continue working with respondent and respondent's new firm, which was the reason complainant received the numerous written requests to have the listings withdrawn. Regarding all advertising, respondent states that respondent has corrected the sign issue, and postcards all include the firm number, which respondent states was a mistake with regard to some postcards. The recommendation is a letter of warning regarding Rule 1260-02-.02 subsection 3, which states that when any licensee terminates affiliation with a firm, the licensee shall neither take nor use any property listings secured through the firm unless authorized by the principal broker, and Rule 1260-02-.12 regarding advertising.
Reese.
Well, at first blush, to me, the recommendation of council is pretty easy. I mean, this was a principal broker who was taking his firm's listings, I'm sorry. I'd be more inclined to increase this penalty in some form or fashion than just to give him a letter of warning, because certainly that principal broker licensee must have known this. He had to deal with it.
I don't know if this makes any difference, but the following complaint is the same parties flip-flopped, and the other one, the respondent has now filed a complaint against the complainant in this one.
But you have to take this one
Yeah.
as this one stands individually.
I mean, if you never said what you just said, this is still, I mean, to me, this is a little more serious than just a letter of lip.
I guess the fact that just because the broker had not signed his own release and went out and started pulling signs and lock boxes, to me, that doesn't relieve him of doing a broker's responsibility. I mean, I can understand that he's mad.
Eve, how does an owner get rid of a principal broker?
Since the listings belong to the broker.
Well, you know, we have a number of firms that are owned by third-party owners, and they hire a principal broker for hire, and the statute says that the listings belong to the firm, actually. So it's, but the owner frequently is not a licensee. So then you have it's kind of a difficult situation because there's usually not someone who steps immediately in to take the place of that principal broker.
Which means you better have one before you fire someone.
Right, but most of the time
answer-
they don't,
yeah.
and they just fire them and then,
Deal with it.
yeah, deal with it.
That really still doesn't give that broker that got fired the right to pull his license. Solicit the listings.
Right, you know, I guess, I mean, this isn't really, this is just an observation. I think that there might be some confusion amongst licensees, and I don't know whether the listings belong to the firm or to the principal broker. And so I think maybe sometimes, especially in the situation such as this, that becomes an issue.
This person should know he is a broker of the firm. If he did, he ought to have been fired anyway.
Well, right, I'm just saying, I think that there is sometimes some.
What about a $1,000 fine and
Penalty.
and a course in ethics? And
Or a
then
violation of what? Which one?
you,
Me pick it, it's your motion.
I'd say Rule 1260-02-.02, subparagraph 3, Mr. Alexander.
What
That
is
sounds
the
good to
fine limits on that one, Julie?
I believe, according to, okay, within the civil penalties rule, a violation of any commission rule or order, the range is $50 to $1,000.
let's give him he or she an ethics course in addition.
So your
Plus
motion is a consent order for $1,000 for a violation of 1260-02.023, and how many hours in ethics?
What is it, 4 hour?
Four.
4 hour, 3 hour?
Well, I know we can get 3, but there is a 4-hour course too.
Make it
4 hours.
And then also attendance at the commission meeting?
Yes, ma'am.
And is that all, the ethics and the meeting within 180 days?
Yes, ma'am.
Okay. So a consent order for $1,000 for the violation of that statute regarding taking the listings, a 4-hour course of ethics, and a commission meeting within 180 days of signing the consent order. Correct? Okay. Just want to make sure I had your motion correct.
I'll second it.
We have a motion by Commissioner Alexander, and you've heard the motion, and $1,000 consent order, 4 hours of ethics class, and attendance of the meeting, all within 6 months. Any discussion on the motion?
Seconded.
Commissioner
Reese?
Grice. Commissioner Grice. Any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no.
Auto two. Hold on.
Motion carries unanimously.
Made the motion.
Commissioner Alexander, and seconded by
Alexander.
Commissioner Grease.
Okay.
Next, we have complaint number 19.
First.
2013017501. Complainant is a broker who was the respondent in the previous complaint presented. Respondent principal broker was the complainant in the previous matter presented. Complainant states that respondent's firm has been running advertisements and provides advertisement copies which offer a free 1-year home warranty if an individual buys or sells a home with the firm. Complainant states that the advertisement does not list the basic disclosure requirements as required by Rule 1260-02-.33 Gifts and Prizes Rule regarding the details of the offer, but states only that some stipulations apply. Complainant states that this is a bait-and-switch tactic, and the only way to know the stipulations is to schedule a listing or buyer appointment where the individual would find that the free home warranty applied only under certain circumstances. Respondent submitted a response stating that respondent's firm no longer advertises or offers this promotion, and the disclosure is changed from the disclosure provided by complainant. Respondent states that respondent was told that respondent could advertise in this manner so long as the advertisement specifically listed that some stipulations apply in the advertisement. Respondent also attached copies of complainant's ads while at respondent's firm, which included the same inducement. Respondent states that this complaint is in retaliation for respondent's previous complaint against this complainant. The recommendation is a letter of warning regarding Rule 1260-02-.33 outlining gifts and prizes.
Was his advertisement in violation, Julie?
Well, the way the rule reads, I've got the number, I ought to have it. The gifts and prizes rule allows the offering of a gift prize or other valuable consideration as an inducement to purchase, listing, or lease of real estate if the offer is made under the sponsorship and with the approval of the firm of whom the licensee is affiliated, which is not an issue here, and in writing, signed by the licensee with disclosure of all pertinent details, including but not limited to accurate specifications of the gift prize or other valuable consideration offered, fair market value, the time and place of delivery, and any requirements which must be satisfied by the prospective purchaser or lessor. Here, this is a complaint involving the advertisement, stating that there's a free home warranty, some stipulations apply. Later on, there's an acknowledgement outlining everything, which would, sometimes you can get a home warranty at that point. The person's not using this anymore. I don't know. I mean, not being in the business, I can't tell. But to me, when you look at the advertisement, it looks like you're getting a free home warranty, and then later on, it does not look that way necessarily. But again, I'm not.
But it doesn't give the fair market value of the home warranty or what the conditions are to receive the home warranty on the ad.
It just says, some stipulations apply, and then that's all laid out in the acknowledgement that they have to sign. In the rule, it says, that it has to be outlined in writing, signed by the licensee. But in a way, this advertisement seemed pretty different than the actual acknowledgement that was later on being presented to the person when they went in and met with these individuals.
Because it doesn't give the fair market value, the time and place of delivery, or the requirements.
Right. And
Doesn't even necessarily always apply. You know, you didn't even always get the free home warranty in this circumstance, so.
Yes, but in the response, he was guilty of doing that himself when he was with the firm. Is that not correct? So he's guilty himself.
He's charging himself.
And this person may very well file another complaint against this person for the same thing. But that's not, you know, that's not what this complaint is just against the one person, so.
And I think the letter of warning is probably okay, just so it's clear to them. I think this has been a very misused marketing tactic. Yes, I'll make a motion that we send a letter of warning, the recommendation of staff.
Have a motion on the floor that we take staff's recommendation and send a letter of warning about the outlining gifts and prizes, and Commissioner Alexander seconds that motion. Any discussion on the motion?
Yeah, to go to Commissioner Frank's comment, I'm not sure what message we send with just a letter of warning, although I think this is a specific case where he's really filing a complaint against a period of time when he was the principal broker, so I can buy into that, but you're correct. I believe there are all kinds of offers and inducements that don't at all specify what the statute requires, and I'm not sure how we need to address that, but I don't want this a letter of reprimand or warning setting the standard for what we may see other places.
Well, I'm not sure that we don't need something put in the newsletter or something, maybe, Steve, that refers to this gifts and prizes, that these inducements have got to be very specific and outline that rule.
I think it's good for principal brokers to be looking at those newsletters and to be seeing who's being fined and what's important to this commission. And when you read that, and you should be reading those things, that you realize, can't be doing this. Well, this will get me in trouble.
And I'm not sure when they see in there that so-and-so violated this rule and they got a letter of warning. Well, okay, I'm running an ad on the radio that doesn't spell out all the specifications, and I got 6 new listings off of it, and it cost me nothing. I got a letter of warning from the commission. Big deal, who cares? I got 6 listings off of it.
Well, who you gonna find? You gonna find the man we just found in the previous case? He's the one.
That's who was doing it.
Well, apparently they both were utilizing
they're
it at
both
one
doing
point, but it's no longer the advertisement that's being used, and copies of the current one were given. And there's also, under the advertising rule, which Eve pointed out to me, and I just had not written it down here, under the advertising rule, Part 5, which is guarantees, claims, and offers, B of that section states, any offer, guarantee, warranty, or the like made to induce an individual to enter into an agency relationship or contract must be made in writing and must disclose all pertinent details on the face of such offer or advertisement.
So like on the previous one, we didn't care that the complainant came with unclean hands. So why should we care on this one if the complainant doesn't have clean hands? If they violated the statute, I'm curious to know what are the limitations on what penalty we can impose for violating it.
A violation of any rule is, like I said, $50 to $1,000. But in this case, this person, like I said, has changed it and shown proof, provided copies showing that it has been changed. So. And
is that person a licensee?
Yeah, they are.
Okay.
A broker or just a?
Now principal broker replacing the other person that was.
So he is now
I don't know if the person was the principal broker or just a broker at the firm at the time.
But I mean, he's a broker. He's not an affiliate, so he should have known better.
It's correct. The person has been licensed since '99, so.
Commissioner McMullen, would you like to amend the motion that Commissioner Franks has made?
No, but I don't. But I think we ought to do something more. I'm open to whatever that may be, but I mean, I think there ought to be some sort of penalty.
But Austin, are you going back to the principal broker we just dealt with? Or are you going with this new principal broker?
I don't,
There needs to be a complaint opened
There's-
against the complainant in this one.
Now, I
but-
agree with that.
But what we have in front of us is this complaint. It looks like there was a violation to me.
Because he admits in his own response that he was guilty of doing it when he was with his former firm.
That's how he knew about it.
Pardon?
That's how he knew about it.
That's what I say. So if you're gonna do something, you can not write him a letter and you can open up another complaint. Can you not?
This original principal broker, to me, was not honorable by the first offense that we see. And unfortunately, we already know that these are the same people. So it doesn't give this person as much credence to their complaint, I think. It, to me, is they got fired, they got in trouble, I'll get you back. I think that's what's going on here. I mean, we don't know. That's
Fair assumption.
yeah.
I'll move to amend the motion to change it to a penalty of $250 in attendance at a meeting.
I'll second.
We have an amendment on the original motion by Commissioner McMullen to assess a $250 civil penalty plus attendance to a TREC meeting within 6 months.
and would,
To who? But who?
the respondent, that's all that we could.
The only portion you can on this instance.
And would you also like to include in that the provision, which I'd forgotten to write in there, underneath the advertising rule that does require any offer, guarantee, warranty, or the like made to induce an individual to enter into an agency relationship or contract must be made in writing and must disclose all pertinent details on the face of such offer or advertisement?
Yes, for violating that and Rule 1260-02-.33.
Now, I'm not talking against the motion or the amendment. The question I'd like to ask Ms. Maxwell, when this respondent, when was he hired as the principal broker? And when was the claim filed? You see?
I don't have that information.
I don't know that it's in here.
It might be in the file.
What I'm saying, was he the principal broker? And is he the principal broker now? He or she? Is
Right
the
now,
respondent?
right now, the person is a principal broker.
Oh, he's not. Who was a? I'm not making sense to you. No, I'm
No,
not making sense.
I think I'd have to look him up on RBS and sort of try to figure out who was
Maybe
what
I can help you
when.
out. All right. So the second complaint, the one we're considering now, was filed 14 days after the first complaint.
Okay.
So there's very short period of time in there.
There's a broker there. Was there a broker there?
Yeah, well, I'm sure that, yeah, I think the respondent was the principal broker during those 14 days because when he broker released his principal broker, he became.
Replaced.
But he was a third party. He may not even be a licensee.
No, they're both licensees.
He stepped-
So was a broker. The third party or the owner of the firm is the broker now. Is that
Is
what
the
you're?
principal broker now, was a broker at the firm before.
Call for the question. On the.
Okay, we have an amendment to assess a $250 civil penalty plus attendance to a TREC meeting within 6 months, and with the addition of the other
I've got the
statutes,
citation,
you've
the
got it
advertising
right.
rule.
Any just
I want to speak against that only because there's only a 2-week window when this could have occurred, or the complainant would have been the principal broker himself while it happened. So I don't know about penalizing the new principal broker on a 2-week period of time. That's,
Well, but he was the owner of the company when
Correct.
this was going on.
And has a broker's
and
license.
has a broker's license.
Yeah, but he wasn't the PB.
It didn't make him liable, though. He wasn't liable until he became the principal broker.
But if it continued for that period of time,
2 weeks.
yeah, for that 2 weeks, it was 2 weeks that he was doing it that he shouldn't have been.
I'm not sure, these advertisements aren't dated, so I don't know if the advertisement that is complained of, I'm not sure who was the principal broker when that advertisement was placed. I don't have that information. It's not a dated advertisement.
With
He
that said,
the respondent submitted a response stating that the respondent's firm no longer advertises or offers this promotion.
Right,
Did his response state when they stopped offering that promotion?
It says, since the complainant's release from our firm in July 2013, they have changed the promotion stipulations, and they've used a copy of the disclosure they're currently using if they offer a home warranty.
And is it correct?
Does it have all the information in it?
The other thing I would wonder too is how long was the principal broker at that company, the first one that we've already fined? Were they just there a short time?
Ms. Maxwell, can you answer that?
I'd have to look that up on RBS. I don't have that in front of me. I mean, I have to, we can look it up. I don't have the names of the individuals in front of me.
Discussing the amendment that was made by Commissioner McMullen for an assessment of $250 civil penalty plus attendance at a TREC meeting within 6 months. Anybody have any other discussion on the amendment
Well, we're waiting on information.
before we vote?
Julie.
It gives the new
Oh, I know.
disclosure.
Oh, I know, we ain't voting.
And this person points out that the rule states that the prize has to be outlined in a written disclosure, not the advertisement itself. So the issue, I guess, with the advertisement saying 1-year home warranty and not saying much would be more of an issue under the advertising rule. The issue of the disclosure itself would fall under the
Gifts and prizes.
the gifts and prizes, and the new disclosure appears to be much more clear. It gives the value of a basic home warranty, and it says at the closing, it'll be authorized to do 100% of the cost of the home warranty when it's allowed. It appears, the current one appears to be more, the written disclosure appears to be clearer than it was previously.
And it does have all the stipulations in it.
It appears to me to be more specific than it was. It says when it's going to be, that it'll be activated at closing, which is the time and place of delivery. And basically that at the closing of the transaction is when they're entitled to it. So it is clearer than the disclosure was before.
I have more of an issue with us just putting this in the paper that all they got was a letter of warning and no penalty associated with it. Because like I said, if I can run an ad and get 6 new listings and then all I'm going to get from the commission's a letter of warning, then guess what? I haven't lost anything.
This person did say that they had sought direction from an attorney and were told that they could advertise the promotion this way as long as they disclosed in the advertising media that there were stipulations to it.
I had somebody tell me that last week, and I said they should have read the law.
Do they have a letter from that lawyer telling them that?
No.
We're discussing the amendment made by Commissioner McMullen, and I think everybody knows what it is. Any other discussion?
I'd be inclined to support the monetary fine, but not the commission meeting attendance. I think he's clearly learned his lesson. That's.
I don't think it hurts anybody to come to these meetings, though.
Ask those people out there if it's hurt.
I think it's important.
All right, let's vote, Mr. Chairman.
Trying to encourage Nashville tourism.
I think if you go back and check the records, it's anytime you sign a consent order, that's part of the consent order.
The question's been called on the amendment. You've heard it. All in favor say aye.
Aye.
Opposed, no. Amendment carries unanimously. Now we're voting on the motion as amended, which is a civil penalty of $250 plus attendance of a TREC meeting in 6 months plus the other things associated in it that Julie knows about.
Let's vote.
Letter of warning with the $250 civil penalty. Any discussion on the motion as amended? Hearing none, all in favor say aye.
Aye.
Opposed, no.
So what did we just vote to approve, Mr. Chairman?
We voted to approve a $250 civil penalty plus attendance at a TREC meeting within 6 months.
Letter of warning.
For those two cited.
Plus some instruction
That was the part that.
outside of the.
Plus what?
That. Your
Instructions.
We replaced the letter of warning in the amendment.
Yeah.
Yeah.
They don't
Okay.
get any instructions.
They don't get any
Well,
instructions.
it will outline the facts in the law within the consent order.
Say what they violated.
Yes, that's what I was talking about.
What do we need to do to open a complaint against the complainant in that matter for violating those rules?
Make a motion. Make a
Now
motion.
just make a motion.
Move to open a complaint against the complainant in matter number 19 for violating the Rule 1260.02.33 and the other statute that you mentioned.
We have a motion by Commissioner McMullen.
Can I get a second?
We haven't gotten one yet.
Second.
We got a motion, now we got a second by Commissioner Grease. Second that motion, that we open a complaint against the complainant.
It's Alexander.
That was Commissioner Grease.
If you don't want me to second
I thought
your
after all
motion,
that, Wendell would have been on it. Can I get a
like somebody
third
else
from
to
Wendell?
second it.
Okay, we got a motion by Commissioner McMullen, second by Commissioner Grease, to open a complaint against the complainant in complaint number 19, AKA 2013-017501. Any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously. Next, we have
Maybe they'll learn they need to quit
Number-
fighting with each other.
number 20.
Number 20, 2013-016191. Complainant states that respondent, an unlicensed individual, is buying, selling, and renting properties in Tennessee without proper licensing. Complainant submitted some information from the internet regarding respondent. Said information appears to indicate that respondent is acting as an investor. Additionally, information was obtained that respondent is an investor who has spoken at meetings for an investors group. Respondent submitted a reply stating that respondent is a real estate investor who buys and sells properties in which respondent has an ownership interest. Based on the information provided and obtained, there does not appear to be sufficient information to suggest that respondent is engaging in unlicensed activity, and therefore the recommendation is to close.
Got another one where it's still being investigated.
It's, I contacted the complainant again. This person didn't have any information to substantiate, didn't have anything to substantiate the claims, and I researched it myself. We actually contacted someone that is a licensee that was involved with an organization where this person had spoken, who said that this person was an investor. The person said they were an investor. I could not find anything to the contrary.
The difference between close and dismiss. Could you straighten me out on that?
If in 2 weeks I get something from this person showing me that that she didn't have, that this complainant didn't have before, it's something that can be opened back up.
Close it.
Mm-hmm.
Okay.
I make a motion, we accept council's recommendation.
Second.
A motion by Commissioner DeShara and seconded by Commissioner Franks to close this file, take council's recommendation. Any discussion on the motion? Hearing none, all in favor say aye. Opposed, no. Motion carries unanimously. Number 21.
201301631. Complainant was the purchaser of a home who was represented by a licensee, and respondent, principal broker, represented the seller of the home. Complainant states the complainant purchased a home with stainless steel stove and refrigerator to remain with the home, which were present in the walkthrough, but removed later by the seller and replaced with an older white refrigerator and an older white yellow stove. Complainant states that respondent first stated that respondent did not know where the seller was, then refused to give complainant's broker the contact information for the seller. Complainant contacted the police with regard to the seller's actions. Complainant states that complainant does not think that respondent was involved in the theft of the appliances, but does think that respondent was protecting the seller by not giving complainant information about the seller's whereabouts. Respondent states that the respondent was out of town when the problem arose, but was notified by complainant's broker that the seller had removed the stainless steel appliances and replaced them with older appliances. When respondent was finally able to get in touch with the seller, respondent states that the seller said that the seller had returned the stainless steel appliances because the seller still owed money on them and replaced them with the seller's older appliances because the seller stated the contract did not specify what type of appliances remained. Respondent states that respondent told the seller that the seller should return the appliances that were at the walkthrough or the buyer could file a civil suit. Respondent states that respondent was unaware that the seller planned to exchange the appliances or that would have been specified in a counteroffer. Respondent states that respondent did not give the seller's number to complainant's broker because complainant was instructed not to do so by the seller and because respondent did not think seller should disclose that information. However, respondent did give the seller's phone number to police when they contacted respondent. Based on the information in the file, there does not appear to be a violation by respondent, and therefore the recommendation is to dismiss.
Isn't there a violation?
No knowledge by the agent.
If it just said stone refrigerator, that,
Now, Janet, if you walk through a house and you show it and there's a stainless steel refrigerator and a stove in there, you think it's that they're going to, you going to think that they're going to substitute it?
well, I have
Seller was
seen it
wrong in doing
happen
that.
more than one time, and the seller, I mean, that doesn't mean the agent had any responsibility to that.
The agent said that they were unaware of that, and even the complainant says the complainant doesn't think there was any involvement. The complainant's frustration arose when their broker called and asked for the contact information, and initially this respondent refused to disclose it to the complainant's broker because it was, information of the client that the client had asked this person not to disclose. But when police called them, the information was released to the police.
I think they handled it the only way they could have.
Is there a motion?
No.
I make a motion to dismiss.
I'll second.
Have a motion by Commissioner Franks to take council's recommendation and dismiss, and Commissioner Grease seconded it. Any discussion on the motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries unanimously.
Last two. 20130171141 and 20130182231. Two complaints submitted against the same former licensee whose license was revoked. Complainants in the first complaint, 2013-017-141, were renters of a property managed by respondent. Complainants state that After respondent's license was revoked, respondent continued to collect rent money for the property which respondent does not own. Complainants state that they vacated the property and respondent has taken legal action against complainants for past due rent, attorney's fees, and late fees, which complainant state respondent has no right to do. Respondent submitted no response to the complaint. Complainant in the second complaint, 2013-018-231, is a property owner for whom respondent handled the rental of the property. Complainant states the complainant held money given to respondent by tenants and held money in escrow for repairs which were not performed. After discovering that respondent's license had been revoked and respondent's office had been vacated, all complainant could obtain for a location was a UPS drop box. Complainant was unable to reach respondent to resolve the matter. Complainant canceled the contract with respondent and hired an attorney who complainant states was able to get complainant's money returned to complainant. Complainant also attached a copy of what appears to be an advertisement for properties for rent placed by respondent. Complainant is requesting that respondent be prevented from continuing to engage in these activities. Respondent submitted no response to the complaint. Respondent has ignored communications notifying respondent that respondent's license has been revoked and may no longer engage in activities requiring licensure under the Brokers Act. The recommendation is to close these and refer to the district attorney for continuing to act as a licensee after the license has been revoked.
I make a motion, we accept council's recommendation.
Second.
Have a motion by Commissioner Shar to accept council's recommendation and close and refer to district attorney to continue to act as licensee after license has been revoked. Seconded by Commissioner Franks. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Commissioner Grease.
So, just in closing on the legal report, we've had Ms. Crop on the hot seat all friggin' day.
I can't believe she can talk that much.
Well, I mean, this morning she was trying to defend actions. Today she's trying to defend recommendations, and just my hat's off to you, and we appreciate it. Although we are a bunch of ornery people sitting up here sometimes, from your perspective, you're doing a great job for us. Thank you.
You're doing great.
The last thing I have is just my consent order, the consent order log that I normally keep in here, just so you all know how I'm keeping track of these. These are, the page that you're looking at is just a list of ones that have not been satisfied. We've actually had a number of consent orders which have been satisfied, and after they are, they're removed from the list. This is just a tracking device, so I can keep track of when they're sent out, when they're returned, and it's just so you're kept abreast of how things are being tracked. It's not really anything more than just for your review, and really all I have.
We could get that unlicensed activity under control, we'd be in good shape.
It's amazing.
Better shape.
It's amazing.
Yeah. All right, that concludes your report. Julie, is that correct?
She's not talking to you anymore. Are you finished?
Your report is concluded, is that?
My report is concluded. That's
Great
all I
job.
have.
Thank you.
Ms. Maxwell can go ahead with it first.
We'll move to the Executive Director's report. Ms. Maxwell?
Yes. We'll start with the complaint report, which is in front of you all on the iPads. And the complaint report shows that the number of open complaints that we have right now is 112. We hear about 95% of them, close to 95% within the 180-day time frame. It's presented to the commission. The commission's acted on those complaints, and if they haven't acted on them, it's normally because they're out for investigation. So that's a very, very high percentage that we're hearing. Julie, again, is doing a great job of getting those presented to the commission. We had 22 complaints received in December. And I can say as of the 1st of January, we've had quite an influx of complaints. So I guess people sort of must have been laying low during Christmas and now have decided to start filing complaints again. In the month of December, we collected $25,000. We've had no one pay any more on the E&O penalty fee, so we still have only collected from 8 people the $500, and that's all we've collected so far from the E&O penalty fee. And right now, we've closed 179 complaints this fiscal year from 7/1 of 2013 to 12/31 of 2013. 147 were closed with no action, 2 referred to outside agency, 6 closed with a letter of warning or instruction, 21 closed with a consent order, and 3 licenses have been revoked. And then there's the disciplinary action report that lists the number of individuals who received penalties, and we've tried to put a little more information in the violation section so that it's a little more clear to someone who's looking at the disciplinary action report exactly what they were they received the civil penalty for. And then there's the pie chart. It sort of has taken on, I guess, a bit of an oblong shape, but anyway, it shows the percentage of complaints and then the number that we received. Are there any questions on any of that? Or did I go too fast?
I didn't realize that unlicensed activity, 18% of our complaints.
Right, we have a
from
lot of
unlicensed activity.
We have a fair number of unlicensed activity complaints. And some of those are in conjunction with, something else that came in with that complaint, but the bottom line is the person's unlicensed. That's why, I think that's why Commissioner Flitcroft always talks about what a problem that is, and it really is a significant problem. Are there any questions on that?
Is there anything that could be done proactively about that, other than just what we're doing?
We have, the statute gives authority to the commission, but some authority to the commission, but we don't have the authority to go in and close down a business. We don't have the authority to force an unlicensed person to allow us to come in and look at their books and records. And any court action has to be taken through the Attorney General's office. So, it's not like there's a real easy way for us to accomplish something. And so we try to open complaints and at least, try to stop some of it. And Julie will send an investigator if someone appears to be a multiple offender. Some of it is advertising on the internet that's really difficult to track down.
Just a lot of enticement with a large real estate commission versus a fine, a small fine compared to what that commission would be. There's a lot of enticement for people, I think.
I know, have you seen any changes across the state within the industry now that we don't have our 4 auditors?
We still have the auditor positions.
Okay. They just start.
What's that word again?
They just start filled.
Correct. Well, we haven't, I don't think that we haven't been made aware of an increase in individuals who are not returning escrow monies. So, we haven't seen that in our office. Whether or not it's going on and no one's reported the people, I don't know. I hope that we can get the mail-in audit is ready to be implemented. It's just that with the former auditors, it's just we can't implement it quite yet. That doesn't really answer your question, but that's.
So, if let's just take this last case we had where we've already revoked a license. We referred it to an attorney general. Why can't we disclose who that person is? Why couldn't our minutes show that we've referred so-and-so to so-and-so's county's attorney general?
To protect the public.
If and nothing, or to at least, that's a good enough reason right there. Why couldn't we do that?
I don't know. It's a matter of public record that we revoked the license. It was done in a formal hearing, and everyone who files a complaint against that person or even calls about that person, if Connell talks to them, he encourages them to go to the police and file a police action, have the police file a criminal action against them or at least investigate it. In Memphis, that was the one way. I don't know if those people are still off the street, but it was one way that we got one set of individuals in Memphis who were causing a problem.
I'm just thinking, I'm a prospect for whatever, and I Googled a person, which I do all the time about everything now. Why where would we be in some sort of legal jeopardy by publishing that name?
That would be something I'd want to check into before we did that, because I'm just not sure about, I'm not sure.
That's just
I'm sorry.
at your leisure.
But we can't, yeah, I mean, because it is someone whose license has been revoked, and that was public record when it was revoked.
Well, and I mean, I'm kind of like John. Marcia, if we put it in our newsletter, revoked license for this quarter, and somebody's name's under it, and we know in our area they're still doing business, I mean, because we don't even know sometimes who it is.
Right, I mean, I mean, you can ask and see if we can maybe put, I mean, those things are already public.
Austin.
They've already been made public, so it seems like you would just be repeating public information that you
So
would
what
think.
specifically would you like me to ask for it to, would it be permissible for us to do?
Well, let's just say, in your report to us today, on a person whose license has already been revoked, why keep it anonymous when you bring it to us? If all we're going to do is refer to the county's attorney general, what's the harm in saying Austin McMullen has been referred to the Attorney General's office for violation of the license law?
And where would that appear?
Well, hopefully it's going to appear more and more in our newsletters. We keep focusing on why these guys are getting penalties. I noticed in the most recent issue of the Tennessee Association of Realtors newsletter, they're starting to itemize, not by person necessarily, but the type of fine each month that we impose, or type of penalty. So I think we're getting the word out, but I don't care where it goes. If we can't do anything more than refer, and we've already revoked a license, I don't know why we up here and the public can't know who that person is. And they could. I could go find out. I think it's public record, like you said, but
It's public record because they were on the DAR report the month that we did. I would think we could do a recap of people who've been revoked. Like just even if it's presented to you anonymously, do a recap of it and say, we understand they're still engaged.
well, I mean, right now we're publishing the names of people who don't pay student loans, make child support payments,
Right.
and other things. I mean,
Right.
if we've revoked a license, I'm putting them in the same category, maybe worse.
Well, they are included on there when it is revoked, but maybe your question be asked if somebody such as this person who's been revoked, but we're referring it to the DA for continuing, could they be included on the DAR or something like that?
I don't know why it wouldn't be in this.
A reporter needs that information.
I mean, there may be people in a certain county who would like to pick up on that.
May need to be leaked.
If it was in your county, I think your citizens would want to know that.
We've asked before about whether we could give those names to somehow have them posted in the county.
DAR report, if it's a mortician or a beautician and there's a violation, they're listed, they're itemized. I mean, I see the names in there.
In the newspaper.
No, I'm sorry. If I want to go online and look at the DAR
Right.
report, they're all listed there. It's just, in this meeting, which is a public meeting, we don't identify, at least in that last case, who the person is. And I'm just curious.
But maybe we could take a recap, and, I mean, if she couldn't disclose it in the report, when the legal report, then we could do a recap, and just so those names stay prominently before people, and they know that we're continuing to hear that.
I only brought this up talking about unlicensed activity, which was a fair question to ask, I think. We just can't get to a good satisfactory resolution.
But we can check into that. I think at a minimum, we could at least keep the names before in the forefront.
I don't know why we would have any obligation to keep it secret.
Yeah, I mean, even if we couldn't do it in the legal report.
Even if it couldn't be done in the legal report, I could see if it could be brought up somewhere else, because I could see how you could say it shouldn't be in the legal report, because you all are considering two complaints here, and if you know who it is, it could color your opinion of.
Yeah, I don't think it should be in the legal report, but I think after it's done.
After the decision's made.
Right.
I can check
could be
into
it,
that.
yeah.
I'd be happy to.
I think that might be a good idea in these repeat offenders. Okay, well.
Then in the News Journal, you want a list of folks that have just been revoked. Did I gather that? Okay.
If that is,
It's public record.
yeah, it's public record now, once it happens.
That's kind of like your permanent record, though. Where is that? Where's the public record? People might not know where to go to get that.
Yeah, I mean, it would be better if we could get it out to the public as opposed to the I mean, the licensees are great, but the public is really who we would like to
One step
reach.
at a time.
I know, but
What's that TV channel that's got America's Most Wanted on it?
Realtors,
Dumbest
most
criminals.
real estate.
Yeah, bounty hunters. We'll stick the bounty hunters on it.
yeah, that would be good. The next is the licensing statistics, and you can see that our overall numbers were up this month, at least our grand total. Our active numbers were down. We had 24,085 licensees who are active, 950 who are inactive, 8,271 are retired, and 169 are broker released. So our grand total of individual licensees in those statuses is 33,475, which is up 46 from last month. Our firms are up 19 from last month. We have 4,120 firms. So our total of firms and individuals in these categories is 37,595, which is an increase of 65 over last month, which is really one of the first months we've seen an actual total increase, a net increase of.
And December with dues didn't show a lot of fallout yet.
Not yet. We've had, I've probably in the last week done maybe 15 voluntary terminations, I would say, and some of those I'm guessing are probably the result of that. And that might also explain the increase in inactive and retired people too. So they may come back. But we've had a lot of inquiries about bringing their licenses out of retirement. So it looks like people are really starting to move again. The other statistics, the additional statistics, show just the change, the number of individual licensees that have changed over the last several years. For instance, in 2008, our total number of licensees was 46,283 compared to the 33,974. But our loss is lessened with each passing year, so that's a good sign. Our exam numbers were down. I'm sort of just skipping around. Our exam numbers and applications were down a little this month. Well, the exam numbers actually were, I guess, up a little, and the applications were down. And that may just be the time of the year. I thought we might get a flurry of applications in because of the fingerprinting, but that didn't happen. So people either aren't aware of the fingerprinting or it's just not a real concern of people. I've gotten about 15 responses back from the fingerprints thus far from the TBI, and they've all been clear. They haven't had any hits on their fingerprints. So I don't know what the rest will tell, but that's what we've gotten in the first 8 days of the month.
I noticed, Eve?
Yeah.
I noticed the gentleman who was here earlier had a fingerprint report. Was that one of our first?
Right. Oh, no, that the individuals who appeared have had to get a TBI report, and so that's why he had that TBI report that he had. Now the fingerprints now they're running through the TBI and the FBI, so we'll have a much bigger picture, and so it'll be interesting to see. But thus far, we've only had a handful come in, and let's see. I broke down the number of license on the last page of additional statistics. I broke down the number of licensees by type, and then I did the timeshare developers by type. And I don't know if we'll have time to really talk about timeshare today, but I broke those down by type as well and by the number of timeshare developers that we have. And I'll discuss any of that, but if there are there any questions on any of those items? Right now we have 16,137 affiliate brokers that are active and 3,376 brokers, 3,797 principal brokers, and 912 timeshare. And those are individuals who are active. That's off the errors and omissions list. So it's individuals who are active with E&O. And by the timeshare by developer, you can see that Wyndham is our largest timeshare, has the most timeshares salespersons in Tennessee, followed by Westgate and Blue Green. Are there any questions about any of that? Just a quick E&O update. As I had mentioned earlier, the individuals who were put in suspension at the very beginning on 7/1 of 2013 pursuant to the new statute have pretty much sort of stayed there, and if they're not there anymore, it's because they expired, except for those 8 people that paid the $500. We're down to 499 individuals who are in suspension. And as I say, that's really been more of attrition than it has anything else. And so those principal brokers, they're doing nothing. They aren't paying. They're not trying to get E&O. And as I say, we've contacted all of those principal brokers a number of times. Are there any questions on E&O? The fingerprinting instructions, we had those, I think, last month. That's just the information that is available to individuals and kind of instructions of what they need to do and what's on the website, which is the electronic fingerprint submission. And it just tells people you have to go to the site, the L1 site, which is the state vendor, and make an appointment. And their little place is all about the state. The next issue, the next part of the presentation is on the exam RFP update. The attorneys who work on the RFP had asked about the term, and when the commission discussed the RFP back in October, the commission voted to have a 2-year term with 1-year extensions, which is what we currently have. The attorneys who do the RFP had asked us really just to have the commission consider, is that right?
Yeah, they just asked that the commission at least discuss and possibly consider just doing a 5-year contract, just simply because they basically said it's very difficult administratively to do the 2-year with the 1-year extensions without much benefit to doing it that way. It limits the number of contractors that want to bid on it. There's more likely to be more people that want to bid on a longer contract, so it increases the field of contractors that are interested. And it just, if there's a reason to terminate the contract, if for some reason, in the middle of that, there's a reason to terminate the person that gets the contract, that can be done. So it's not as if you're 100% locked into the 5 years. So they just said basically that from their point of view, there's not much of a compelling reason to do it this way, and they didn't know if the commission would consider just doing a 5-year or if you wanted to stick with the 2-year base with the 3 optional renewals. Does that pretty much cover it?
I have no fault with their logic at all. And so, Mr. Chairman, I'll move that that contract be offered as a 5-year base term.
Have a motion by Commissioner Grease,
I'll second that.
making it a 5-year contract, seconded by Commissioner DeShara. Any discussion on the motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
We hope that they're working on the
I'll touch base with
contract,
them.
and they've had it since you all discussed it in October, so hopefully
We
it's.
talked about it in November with them, I
Yeah,
believe.
early November.
I'll touch base with them to let them know about this and as a point of reference for kind of seeing how things are coming. We should be getting a draft soon, so we hope.
The next order of business was just an update on the subject matter expert summary, and it was really just to let the commission know who actually attended, and everyone who attended really, I think they benefited, and certainly the licensees and applicants benefited from having those individuals there. It was a long day, and anyone who's done it, and I know Commissioner DeShara has done it, it's a pretty arduous task, but everyone who was there really did a great job and contributed a lot. Everybody talked to was there, except for Steve. He never said a word, but,
Council Crop was only there for half the time.
That's right, she was there for only half the time. She was going to a Christmas party.
Now we know where
That
your
makes sense to me,
priorities
too.
lay.
But I did make it there on time, unlike Mr. McDonald.
Yes. But it was, anyway, it was very productive, and they will roll out a new national and state exam around February the 1st. PSI will, and these questions that we worked on will be first done as trial questions, and then they'll become real questions if they shake out. But it was interesting to see some of the things that I thought that brokers knew they didn't know, and some of the things that one would think that you wouldn't know they knew. So it was kind of an interesting sort of exercise. The next order of business is the Arello Mid-Year Conference, and I know it seems like it's a long way away, but we have to have the justification written, as you know, within 60 days of the time has to be turned in upstairs. So our 60 days will be here shortly. The mid-year meeting is in San Diego, California, and it's April the 9th through the 12th, which is a Wednesday through a Saturday. And I don't know which of the commissioners is interested in going, but we need to know that. And then the Philadelphia is where the annual conference will be, and that's in September, and that's a Wednesday through a Sunday. It's the 17th of September through the 21st. And so for the April 9th mid-year meeting, our justification will be due February the 9th, or, thereabouts. So will be before we meet again, I think. Or it'll have to be pretty much done before we meet again. So who is interested in going to the mid-year meeting in San Diego?
I don't know what this really is. What is this?
Arello is the Association of Real Estate Licensed Law Officials.
And it's where we all go and discuss what's going on nationwide. And I'm on the Fair Housing Committee now, so I would like to go.
There's anywhere between 5 and 9 commissioners in every state, 5, 7, or 9. And it's all 50 states, plus the District of Columbia, plus the 11 Canadian provinces. They've all got a real estate commission. And there's, about 45 foreign countries?
Probably by now. Believe it or not, South Africa sends a fairly large contingent. Namibia was it Namibia?
Yeah.
Or was that sent one last time? I mean, it's very, very interesting. I mean, it's the regulators and commissioners from almost all the states send someone. Florida doesn't, and California usually does not. But most of the other states send a number of representatives.
Kentucky sends all theirs. Hawaii always sends.
Mississippi sends all theirs. We aren't allowed to send all of ours. We can usually only send 2. But we have to
You need to know by.
We have to turn in a justification at least 60 days in advance for it to start making its way up the hill. But when we do the justification, we have to have identified the individuals who want to go, so that we have to know, like this airfare is for this person, and that's the way it has to be written. So that's why it kind of locks someone in if they want to go. I mean, you can always back out, but you can't switch. Like if you wanted to go, we couldn't switch John for you. Wouldn't be a real easy thing to do 15 days from the meeting.
Is the administration still stuck on that 4?
When Assistant Commissioner Giannini was here, was it in November? He discussed, that question was asked, and his answer, I believe, was that we could ask for other people, but we would have to be able to justify the other people. I think they're going to stick with 4. It's got to go, it goes all the way up to the governor's office. And so, I don't know. We can try. I don't know. I think you can do whatever you all decide to do, and I'll have I can get a verbal indication whether they would let us have one.
The newer commissioners, such as Gary and Marcy, now that she's on, John.
Marcia.
Marcia, not Marcy. Marcia.
Marcia.
But anyway, Wendell and I, we don't need to go, but.
You may have wanted to go.
But anyway, I mean, I'd better to ask. If we go ahead and ask for more, see what they do.
Well, we actually have sort of 3 or 4 new commissioners, because we have Commissioner Bloom and
Yeah.
Franks and DeChara and
I'd be
Greece.
interested in going if there's a spot for me, but if somebody else needs to go, I'll defer to them.
So let's do it. So let's do it this way. Who would be the most interested in going? Who would like to go but wouldn't be heartbroken if they couldn't go? So that I can ask for 4, but know that if we can't get 4, that 2 people really got their hearts set on going.
And heartbroken was a consideration?
If
I would not be.
heartbroken was
I
a-
would not be heartbroken.
That's what, so I'm sort of trying to gauge the, okay.
You 3. The 3 of you.
I think mine would have to be approved through the legal department.
Yeah, hers has to go.
Okay, you go to the legal, but,
But
it'd be-
but I-
Steve, you and Eve definitely need to be 2 of who goes, whether 2 commissioners, 3 commissioners. And this also will vary from state to state. Some states, they'll send as many commissioners as they want to go. But Tennessee, being a little more conservative, a little more cost conscious, they don't look at things quite that way.
I would love to go, but it's not going to kill me if I don't go. I mean, I know the least of anybody up here, so maybe you need somebody that knows a little more than me to go. I don't know.
Actually, there is a commissioner college that they do at Arillo, and I have not had the opportunity to do it because you have to either go in a day early or stay a day late. That is for new commissioners to give you an idea of what you should be doing on the commission. Steve?
And that was asked about also, if you remember when Assistant.
Yeah, and I
Commissioner
would like to
Giannini
do the
was
commissioner
here, and
college this
I
time.
think that's, Commissioner Alexander and Stevenson might have done it back in the day.
Yes, I
Back in the
did it.
day.
That's why they're so knowledgeable.
That's right, exactly. That's why they know Robert's Rules of Order so well. But I think that, I do think, I've heard everybody say that it's a very, very beneficial thing, and we can always ask if.
Well, in the commissioner forum that I went to last time, they were highly recommending that for new commissioners and how beneficial it was.
And for the commissioners to add to Director Maxwell's report, Tennessee is well represented when we do go and what no matter number, because Commissioner DeChara is on fair housing. Director Maxwell is what?
Membership now. I think I was appointed membership, and on 3 or 4 other ones, but.
I'm co-chair of the Exam Accreditation Committee.
And I'm a director as well, so I really, I'm a director of Arello for our district. So anyway, it is very beneficial, and it's great to see what the other people are
Tomorrow
doing in
about it?
other states. Huh?
May I call you tomorrow about it?
Sure, that'd be great, yeah. And so, Commissioner Bloom, you'd like to go, and then, if you could, you wouldn't be heartbroken if you couldn't go this time. And what about you, Commissioner Grease?
I'm pretty busy that week.
Okay. So
I think that's a no. He knows he's going to be busy.
So did you want to carve yourself out for the annual one in
I
Philadelphia?
might. Well, what dates were those again? I'll check my schedule.
Would you like me to email you about that?
Yeah, tell me later when that is.
I'll email you about that. Okay, so we'll ask about these. I think that it would be best if the commission made a motion on the people that the individuals, both commissioners and staff, that they would like to go, so that we have that in the form of a motion, and then we can submit it in that form.
How would you like this motion to state?
Well, I just think that it would be, if it just said the number, like Janet, Marcia, Gary, Eve, Steve, and Julie, the commission would like for them to be able to attend the meeting in San Diego, the Arello mid-year meeting in San Diego, April 9th through 12th. And if those 3 commissioners would like to go to the Commissioner College, I think you should add that in as well, so that we have it in the form of a motion.
Can you make that motion, Commissioner Alexander? Since you aren't
According
going.
to Robert's rules.
Yeah, according to Robert's rule.
Since you've been to that college.
And since you've been at college.
Graduated from a college. It would be my motion that our staff, since they're all on some committee, that they be the first three to go.
Yeah, name them out.
That'd be Eve Maxwell, Julie, and Steve.
You'll get from the legal department.
You-
Julie's not on the
Yeah, but I
committee.
mean, I can ask them separately. It'll be
Yeah,
fine.
but-
Okay, those two plus,
And then the commissioners, Ms. DeChar serves on some committees. She would be the next choice. And then Gary.
Is it
how-
Gary and Marcia?
Yeah. Excuse me, I was leaning back looking at them talking. But those and y'all, so you put in for 6 people, 3, 4, 5, for 6. And those 6, those three commissioners are who I named, and the 3 members of the staff that I made, and that's my motion.
Would you like for them to attend the commissioners to attend the Commissioner College? If
Yes, most definitely, especially the 2 new members need to go to Commissioners College.
And to give us a written report back of the entire trip.
Some things you need not report on, just report on the most important things.
do I hear a second to the Commissioner Alexander's motion?
I'll second that motion.
Yeah, since you aren't being named, you can second it.
Everybody else gonna have to recuse themselves.
Yeah, everybody else going to have to recuse. There's 3 of us on the 3 going to get to vote. Anyway, any discussion on the motion? Let the record show the reason Commissioner Grease's name didn't get mentioned is because he's going to be busy that week.
I already feel it.
And in September too, probably.
Call for the question.
All in favor say aye.
Aye.
Opposed, no.
And I recuse myself.
Oh, don't recuse yourself. It's,
Wait,
you believe in it or you don't.
Yeah.
Right, you could like vote for yourself. I
You
mean,
can vote for
Okay.
yourself. Okay, yep.
Okay.
It passed unanimously.
We'll vote first. Liz.
So let me go, this is not on the agenda, but if you all would like to get a plaque for former Commissioner Haynes, the protocol now is for the commission to vote to do that. If we didn't have the time to do that before, but for Commissioner Haynes, if you all would like to do that, then if the commission votes to do that, it's my understanding that that we will be able to pay for it.
Same time, so we'll have to do this again.
Just go ahead and get his.
Just like to
order.
list everyone and their terms of expiring.
While you're assessing, just get it up for him one, because he's for sure going.
I would like to make a motion that we order a plaque for Commissioner Haynes. Second.
I have a motion by Commissioner Nashara
We'll have words on it, it'll just be a-
and seconded by Commissioner Franks that we commission get a plaque for Michelle Haynes' service on this commission. I have a motion and a second. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries unanimously. Now, Ms. Maxwell, when are we going to give it to her?
Well, we have to get it first.
Okay.
She's in Cuba this week, isn't it, I think?
Oh, so
Yeah.
really wouldn't want to be sending it down there, probably
No.
wouldn't really get to her and all. We'll have to see what the.
Okay, when you get it. One of our commission meetings, either in February or March,
Right, yeah.
at the appropriate time.
Yes, of course, at the appropriate.
We're just going to order it. We're not going to give it to her. We're just going to get
Send
one.
a UPS and hope it gets there, you know.
Okay, what else do we
Okay,
have?
so,
I got an idea about that.
How about
Okay.
that?
Give it to her in May.
In Jackson, right?
Yeah, down at the farm.
She may not want to come to Jackson.
There she'll come.
everyone wants to
Yeah.
come to Jackson, don't they?
Well, I would hope so.
I'm too busy to go to see it.
We'll figure that out. Okay, what else on your report?
Okay, so the timeshare is sort of a long piece, and I can wait till next month and send you all additional information on that.
Okay.
Mr. Chairman, I move we defer that report.
Motion been made, we defer the timeshare industry overview until next month. Do I hear a second?
Second.
All in favor say aye.
Aye.
Opposed, no. Motion carries. The timeshare industry overview has been sent to next month. Now, budget.
So, and then were there any questions on the budget? I do apologize that you all didn't get the information that I sent on Friday. I have no idea where it went, but It obviously didn't go to anyone, but anyway, the budget was included in that, and I hope that you all maybe on Tuesday got a chance to look at it. I mean, I sent the information again on Tuesday, so I hope that everyone got that information on Tuesday.
Line on it?
No, I mean, it wasn't really, it was, well, our revenue was up, but it was not much different from, last month. I mean, as far as the salaries and all that go, that's the same carryover from month to month. So there wasn't anything that was really different about it from what you had seen last month or the month prior. But as I say, I apologize that you all didn't get the stuff, that you had a chance to look, had a lot of chance to look at it. But anyway, so if there are no questions on that, then I think that's all I had to discuss.
Okay, Commissioner Alexander?
Ms. Maxwell,
Yes.
where are we going to stay next month? Where's the commission going to stay?
The Sheridan didn't seem all that excited about,
And you're not going to go back to the Sheraton.
I don't think they're gonna.
I've had a
how
lengthy
is the-
discussion with them.
Oh, you, I think that the 122 is just not cutting it with the Sheridan, not when they're charging, what, 325? Yeah, I think that's,
It's not only us, it's.
I would assume.
Any state entity, they don't want them anymore.
They're pretty popular right now, they don't, yeah.
Yeah.
And what's your impression of the,
Well, I just, so many places don't want you. I'm satisfied where we stayed this month. I don't want to go back to the Hampton. I'm not going back to the Hampton.
right,
I'm
the
gonna
place
sleep
where
in
you
that
had
basement.
we're in the basement. Right, but the place you're at this week, that's okay. Well, I think that Steve had asked, tried to get the reservations in advance, and what the girl told you that it was a month-to-month deal?
Well-
For our situation, because of it being, for our situation, because it's the state, we looked at 3 months in advance. She and their computer system internally, I actually spoke to someone in Nashville. They don't open up staterooms until 30 days ahead of time. So February's calendar for their bookings is open now. But it would be a month to month, like in February, we call for March. And I tried to stress that if this is a successful stay, we can go ahead and plan for 10 months. We could lock this in for 10 months.
Last
But
night is pretty successful.
very good. And unfortunately, the manager wasn't able to
Well,
accommodate.
She likes you all, though,
Wendell's
and
got
maybe she
the-
thought y'all were good.
Wendell's got the contact person's name.
Great.
We've had a conversation with the manager since you have,
Fantastic.
live and in person.
So they liked you all, they thought you all had.
They think we're good, they'll keep
appointment and
us.
all.
To our face, they did.
And they weren't obstinate about it. They were very as accommodating as they could be without being
In the
accommodating.
So,
Either that be as Maxwell, or I'm going to come into your house. I'm not going to sleep
Well,
in the
that's,
car.
I've got extra
done
rooms, so, yeah, that would be fine. That's right.
Yeah, Commissioner Grease won't have to sleep on the doggy floor.
No, he wouldn't have to, he might have to share with someone, though, but we do have a couple of bunk beds he could sleep in.
Now, does anybody else have? If not, since this is, and we'll, licensees, we should be finished here in about 5 minutes. We'll have y'all out of here. Steve will be in charge of you. Any commissioner, it's customary at the end of our commission meeting, we have commissioner reports. Anything you'd like to say? What would you like, Commissioner Franks, would you like to give us your first day impression of being on the Real Estate Commission?
Well, I thought it went very smoothly. It just more and more reinforces the importance of this commission and the things that are going on. That there really has to be, there has to be, I'm a rule follower, and I like people who are rule followers. And if you tell me this is the rule, I like to do it. So I think it's very important that we always keep things black and white and always do the same consequences as we were talking about earlier. But I've been here twice, just in the audience myself, just to really, as a principal broker, just to learn. And so you can never learn it all. and we don't know it all, and we'll never know it all. But I think it's been a really good experience for me today, and you all are very nice and kind.
Some of us think we know it all.
Commissioner Bloom.
No, I don't have any comments, thank you.
Commissioner Alexander.
I've enjoyed being in your presence, man.
Thank you.
I look forward for till 15. I've got a year and a half. He thinks I'm going with him.
No,
I'm not going.
no, I want you to stay.
Other
Okay.
than that, that's all I have to say.
Two things, Marshall, we're glad you're on board. You had some class that Janet had originally brought, but the rest of this group is marginal at best, in my opinion. So I sent the commissioners a summary of a new appeals court decision that ultimately held the principal broker responsible for the acts of its licensees. And the question has been posed to me since that time, how does the errors and omissions insurance fit in with the responsibilities of the principal broker? For instance, is failure to supervise covered by errors and omissions insurance? I have no idea, but I'd love to get that answer if at some point you could make sure I knew it black and white.
I'll see if I can get an answer in somewhat black and white from.
I'd really
That
like
would be
black and white
great.
if we could.
Yeah, it might be
it's
kind of
somewhat
gray,
like
they
that,
are
that'd be great.
insurers. But, and, Cindy is an attorney, so sometimes you get that. You know how attorneys are.
Well, they go round and round and
Yeah,
never really
yeah.
answer the question a person's
So
asking.
it kind of
as
gets
far
in
as-
their head, and can't get rid of it. But I'll try to find out an answer, or at least some answer.
Thank you.
Commissioner DeShara.
Marcia, welcome aboard. Glad to have you. And I'm glad to have another lady on board. With Michelle going, I was afraid I might have to manage these gentlemen all by myself. And Julie, we're glad you're back this month. We missed you last month. And I'm just glad to be here in another year, and it's going to be a great year. Look forward to serving another year with you guys.
No. You can't be that lucky. Commissioner Franks, I think just from the one day that we've been able to share with you and your input and your involvement so quickly into this commission, we feel like you've been here. I feel like you've been here several months instead of just one day. But anyway, Governor Haslam, I think, used some wise judgment in appointing you to this Middle Tennessee seat. And we're glad that we're going to be serving with you. And those of you out there, if you don't know, you licensees, all of us, all 9 of us up here, we're appointed by the governor. We serve five-year terms, and I'm into my second 5-year term. This is my 10th year. And by statute, you can only serve 2 consecutive 5-year terms. So I'm coming off this commission at the end of June. June the 30th is when my term expires. But we do this for the money. We get paid $50 a day. Every day,
We're in session.
every day we're in session. Today, this month, we're going to make $50 because this is the only day we're going to be in session.
That's your taxes.
Less the taxes. Plus, but they do pay us mileage to get here and go home, and then they reimburse us for our motel where we're staying. But
On the state rate.
on the state rate.
If it goes beyond that, we pay that.
But we're glad to have served. We take seriously what we do because our job, and the reason the Real Estate Commission was enacted in 1951 was our job is to protect the citizens of Tennessee. Our job is to protect the public against sometimes real estate licensees that don't play by the rules and they don't do things the way they should. But I want to encourage every one of you, you've gone through this legal report and listened to all these complaints, you can greatly diminish the probability that you're going to get a complaint filed against you if you will disclose, and let everybody know what's going on. And you can get along much better in this industry, and you'll be much more successful if you'll do that. But anyway, we hope this has been beneficial to you. We hope you've learned something, but we want you to take it back to your offices and share some of the things that you have learned, one of which any licensee can come to a commission meeting and get 8 hours of continuing education. Just for coming, sitting on the back row, cost you nothing, don't have to take a test, just coming to a meeting, you get 8 hours of continuing education. Those of your fellow licensees that need continuing education, it's a good place to come and get it. And just spread that word, let people know. And I'm finished, and Steve McDonald, you're in charge of this group.
As soon as you adjourn the meeting, those that are in attendance, make sure that you sign out for today and you pick up your sheet. I will send that upstairs to Betsy Bowman, and she'll work on reinstatements tomorrow.
You don't have to come back tomorrow. You're finished today. And staff,
8 hours
Eve,
continuing education.
Steve, Julie, y'all have anything?
No. Just be sure to sign out.
Anybody else? This meeting is adjourned. Have a successful year, all of you.
It's adjourned.